very urgent.
Yes.
My lord, already judgment has been fixed for pronouncing on 27 July. My lord, forced will
27th July.
27 July.
What is
And
the order under challenge?
my lord, challenge handwriting is not in a forced July. My lord, application was made for appointment, it was rejected. This honorable court admitted my application and my lord, directed me to serve copy. I have made everything is ready. My lord,
Hand over the slip.
kindly, my lord.
Please indicate the urgency. Hand over the
Well,
slip.
I have said it. Actually, it is appearing in the item number.
You have indicated the item number. All right.
Monthly
May I
list.
be allowed to mention this matter? My petitioner is 90 years old, my lord. My lord, she has filed an application with a prayer for expeditious hearing of the appeal, misappeal, pending before the learned court below. My lord,
Please hand over the slip. Upgradations, please hand over the slip mentioning the urgency.
My lord, item 2286. 15th is the date.
Please hand over the slip.
ঠিক আছে আপগ্রেডেশন না ঠিক আছে কোনো ব্যাপার না আরে হবে
Matter lordship. One matter was running under the heading new motion 3 as item number 558 of Friday's list, but today the matter is not running in the list.
Is not running in the list. এই দেখে নেবেন তো এটা লিস্টে নেই বলছে।
Your Lordship, if I may be permitted to mention, it is for upgradation, but the next date when the trial court is on 23rd July. Kindly keep it.
Please indicate.
May I permit to mention one matter, Lordship? Child custody matter, child is extremely ill. So,
Upgradations, please indicate the urgency. Hand over the slip.
May I mention, my lord, there is extreme emergency, my lord. I have filed my 7-1 and 7-2 variant type. The court has passed the order, immediately I have deposited. Now, in 7-2 application, court rejected my 7-1 application, says that my deposits are bad deposit because I have filed the application.
Hand over the slip.
My lord, the date is fixed on 17.
Your Lordship,
How many bands you are wearing, Mr. Pan?
Earlier was by mistake. This one is correct.
Lordship, may I
So that
permit
is
to mention one?
I was running to this court. Now, my lord, possibly your lordship will not take up this matter for release.
ওটাই to be mentioned দিয়ে দিন for
Your Lordship,
restoration application.
restoration applications. Please hand over the
My
slip.
lord, in
for expeditious disposal, Your Lordship, there are 6 CO regarding the expeditious disposal of LA cases, which is pending in the learned Alipur court for execution. But it is more than 7 years. It is
Please hand over the slip.
my lord, mentioning under inclusion under expeditious hearing, my lord.
Hand over the slip.
Your Lordship.
One matter inclusion in the list challenging the order of the DRAT whereby the seal has been set aside.
Motion.
Yes.
My lord, these are 5 civil applications against the execution before the collector office. These are pending for the past 3 years, my lord.
Hand over the slip. Hand over.
Your Lordship, I have filed order 7-11 in the ejectment suit, Your Lordship. Without hearing me, the learned trial court has pleased to pass an order
What do you want? Upgradation.
for the inclusions, Your Lordship. The court has fixed for passing the order, Your Lordship.
Your Lordship, may I be permitted to mention? Your Lordship, earlier I also mentioned that matter that order 26 rule 9 has been turned down and tomorrow is the last date. Otherwise, the matter will be advanced in court below. Your Lordship, kindly hear the matter, fix it today at least.
What is the next date fixed for?
14th of July. And
For what?
Order 26 rule 9 hearing for getting necessary order from the this honorable
This is
court.
rule line hearing.
Yes, my
Order under challenge.
order 26 rule 9 has been turned down and we have adjourned the matter since then and we have filed this
Next date fixed for.
tomorrow
For what?
for to getting the order from this court.
So please go through the brief then.
Your Lordship, may I permit?
My lord, I am praying for inclusion in the daily list, the monthly list, item number 872.
Hand over the
May I be allowed to mention a matter?
Deeply obliged, Your Lordship.
This is in civil revisional application. An interim order was passed on 13/2/2026, thereby directing the petitioner, the husband, to give a monthly
What
allowance.
do you want? Upgradation. Please hand over the
May I
slip
be permitted to
mentioning
mention one matter, Your Lordship? It is for inclusion. There is a CO regarding the transfer of transfer application under section 24 regarding a mat shoot, which is still pending in from 2024 in Paschim Medinipur.
24. I do not have any determination.
My lord, may I be permitted to mention one matter, my lord, for upgradation. My lord, the petitioner
Upgradation,
is
please hand over the slip mentioning. You always come with peculiar facts.
This is Millard for non-compliance of this court's order. Millard, in a matrimonial proceeding, what happened, Millard? Millard, custody matter, Millard became a person.
What do you want?
What happened, Millard? We reached a settlement. Regarding the settlement, parties were sent to file 13B.
Parties were sent to?
Sent to file 13B after recording the settlement. Now, Millard, what happened, Millard? The wife, Millard, has done his part, has filed 13B jointly with the husband. Now, the husband in 13B is on 3 occasions is not appearing. Now, the trial court, Millard, by its rule, says, I cannot give it unlimited time to husband to appear. Millard, if the husband doesn't appear, Millard, 13B fails. Now, Millard, in that situation where a settlement has been reached, recorded in this court, now, Millard, point 13B after I have withdrawn all proceedings against the husband. Now, the husband is not turning down. That's the problem, Millard. 31st July, the trial court has fixed as last chance. 3 occasions they have adjourned. On my request that I will taking recourse to High Court to bring the husband before me. Now, Millard, this problem is
What can be done, Mr. Chatterjee? Can the husband be compelled?
by police. He should be brought before this court because he has given an.
Have you gone through the recent decision of the Honorable Supreme Court on this? If in a 13B,
13B, Millard, pursuant to settlement recorded in this court. Millard, it's not that unanimously or Millard without coming to this court, a 13B is filed. This is the change of circumstances. Where this court Millard directed us to file 13. Millard, we were fighting with each other in civil.
hand over the slip. Yes.
May your lordship permit me to mention for upgradation?
Please hand over the slip, indicate the urgency.
May I permitted to mention one matter, Your Lordship? This is a matrimonial suit
What do you want?
for inclusion.
Please hand over the slip.
My
Yes.
lord, may I be permitted for inclusion in the list? One matter that the urgency is that after
Motion.
yes,
Hand over the slip.
But this Millard, that I have challenged, Millard, and tomorrow is Millard, hearing of the order 7 rule 11.
Hand over the slip. Yes.
I'm on notice.
Lordship, may I be permitted to mention a matter? Lordship, this is an Article 227 matter. It was taken up on 8 July. Lordship had been pleased to fix it on 14 July. Lordship, my senior counsel, my leading counsel, Mr. Ratnako Banerjee, is not available on 14th. Lordship, I'm praying if the matter could be taken up on 16th instead.
Let it appear, then mention. Yes.
It is adhering in the list, Millard. It is adhering. It's for extension of interim order.
Extension of interim order. When it is expiring?
It is expiring by the end of this month.
By the end of this month. So extension of interim order দিয়ে দিন ওটা।
Millard, the 2 matters Millard, for inclusion in the list, Millard, my suit has been stayed. Millard, in a suit for declaring.
Sir, what heading?
New motion, I am not getting any chance since 2025. 2 matters, Millard. I for the landlord in both the matters, Millard, suit has been stayed, Millard.
Yes. The matter may be placed under to be mentioned for release, my lord. Is a Baripur court matter, my lord, in which the concerned advocate is involved, my lord.
May I be permitted to mention, my lord, this matter is with regard to jurisdiction of the court. This court has heard the matter and fixed the matter for hearing after giving the order. The matter was fixed for hearing on 10th of May. 14th of May. My lord, thereafter this matter is.
Wait, hand over the
My lord,
with
my
regard
lord,
to the same
just
matter, on the same day, another matter has also heard.
hand over the slip. Yes.
my lord, it is a bid for extension of invention that has been obtained. Kindly.
No urgency. Yes.
My lord is kindly to file an urgent 227 application without certified copy.
The urgency.
The urgency is, lordship, the order directs release of a sum of rupees 2.63 crores to the opposite parties in violation of an order of Honorable Supreme Court. Lordship, if that is released, lordship,
The order was passed.
10th July, last Friday.
You have not applied for the certified copy?
I have applied for the certificate.
You have got the server copy?
I've got server copies here.
My lord, I have also the server copy.
Leave without
Yes,
certificate.
call the list.
Great. may appear tomorrow, my lord. Tomorrow.
On the repetition, my lord.
Writ petition stands.
Do you put my lord opposite parties?
I'm hearing for the petitioners.
Yes.
My lord, the petitioners are the defendants in a.
Please use the microphone.
I'm sorry. The petitioners are, my lord, the defendants in a partition suit.
Yes.
And the partition suit has been instituted by a construction company.
What is the order under challenge?
My lord, the cross-examination has been closed, my lord.
Cross-examination of whose cross-examination?
PW2. My lord,
PW2?
yes, my lord.
Why? How many adjournments you have taken?
My lord, one adjournment.
One.
My lord, kindly comes to the. My lord, this cross-examination was earlier closed by the learned trial court, whereas, my lord, this honorable court was pleased to allow the same by allowing a revisional application.
Again, you have defaulted. What
No, my lord. No, my lord. No, my lord. Only once.
Where's the certified copy? Oh, 5-6.
Yes.
5th of June.
5th of June, my lord. 5th of June, not 5th of June, 9th of April 2026 was the date of rejection.
But you have challenged the order dated 5th of June only.
Yes, 5th of June. My lord, PW1 was given. The cross-examination or the examination of the PW1 was allowed to be conducted during the year 2023 and 2024, more than 1.5 years, my lord.
Yes, Mr. Dattu, what do you say?
My lord, my submission. Your lordship kindly produce the orders. My lord, page 71 first. Order of the Honorable Court. That is the direction. Page 71. Order dated 8/6/20. Sorry, my lord. Page 71. This is the first order. This is the first order, 10th of February 2021. Then, my lord, your lordship find. Page 72.
Pending applications.
Pending application.
Yes, then?
Then page 72. Page 73.
Yes. This also pending applications.
Yes. But subsequent to that, my lord, two subsequent
pending application, if there be any filed, then the suit, yes.
Then,
this was in 2022, yes. Then,
2021.
sir, please wait.
I'm sorry.
Page 74.
Yes.
My page 74.
Paragraph 3
Paragraph 3.
Yes.
Non-appearance of the defendant.
Yes.
You go to they do not appear.
Mr. Doctor submits that as per order of this court, petition filed in order Rule 10 has been disposed of ex parte due to non-appearance of the defendants on 7th April 2021. On the same date, on 7/4/2021, the suit was set for ex parte hearing. Admittedly, the suit was filed on 9th January 2017. The defendants entered appearance on 17th January 2017.
After 5 years.
Soon after their appearance, they did not file written statement. The court allowed their file a written statement. We consented that they may be permitted to file written statement. Thereafter, my lordship, they are taking time over different occasions. Page 112.
Mr. Datta, how many witnesses you have?
two witnesses, my lord, one witness is closed, PW2, after.
PW2, the cross-examination has been declined.
No, after the order of the Honorable Court, they are given chance to cross-examine, they cross-examine and thereafter closed. Then file recalling application again.
Recalling of PW2,
PW2.
cross-examination done.
No, my lord. No, my lord.
They have not enclosed.
No, my lord.
I will come back to you. Yes, please show that cross-examination done. That is the application for recalling. Please show me that application.
Recording application of page 104.
Page 104, you also kindly consider.
The
Paragraph 4 and 5.
Paragraph 4, 5, you also kindly consider. In terms of the direction of the Honorable Court, they have given chance to recall, and then the cross-examination closed, and thereafter they file application. This is totally casual application. There is no grounds has been set out. Only two grounds. And my lord, then my lord, you will also find that page only their intention to drag the matter.
On the date, the advocate was not present.
This advocate, my lord, on his ground, my lord, I have brought the entire order sheets. If you lordship, if you lordship gone through the order sheets, you lordship will be astonished how many times on the ground of learned advocate, you also kindly consider the entire order sheets. I have my lord, clerk, my lord, you also kindly excuse me, my lord.
Each and every date asked by the
Since after 5 years, they filed in statement. And we also want to cross-examine the defendants. They are not coming.
My lord, this is not so simple, my lord. There is an application under section 4 of the Partition Act, my lord.
I will come back to you. Let him submit.
Yes. You also kindly see the conduct of the defendants. After 5 years, filed in statement. Then the PW2 was closed initially. Then, my lord, there was fixed argument. Then they filed recalling application that has been allowed. Then they filed written statement, and thereafter they, by the order of the Honorable Court, they filed written statement. And then, my lord, the matter was fixed for hearing.
Page 112.
My page 112, you will also kindly consider.
Last order of justice.
Last order of the Honorable Court.
112.
Last order. We have consented.
I have consented, my lord. You also kindly consider.
Paragraph 40.
Paragraph 4 onwards, you will also find prayer of the petitioner to recall PW2.
So this was recalled.
Recalled, you have cross-examined, and the specific direction on the date fixed that should be completed.
No.
But you have also kindly.
Then what happened?
He cross-examined.
Partly cross-examined, then.
No, he cross-examined, entire cross-examination closed. Then the court held that.
No, pursuant to this order, 13th of February 2026, what is the next date for cross-examination? Please show me which order, by which order he has cross-examined. After this order has been passed.
You will also find.
17th of April.
17th, 17th April, then they have
17th of April. Where is the order dated 17th of
They have
April?
enclosed order number 108. You will also find as per this resolution court was closed. Then, my lord, next 109 fixed for evidence of the DWs.
Yes. So defendants have adduced the evidence.
They have not come. Then the file application for further recalling, for further cross-examination of, and in the petition there is nothing materials, and the court held that there was the earlier order of the Honorable Court, there's specific direction to complete the cross-examination on the date fixed.
Where is your application for recalling?
Yes, my lord. But after the order of this Honorable Court, in terms of CO 4248, that is on page 112, the cross-examination was allowed to be started.
Where is that order?
112, page 112.
Page 112 is the High Court's order. Thereafter, the trial court's order, where is that?
Yes.
After
that, my lord, defendants were allowed to cross-examine.
Page 101.
to
101.
101.
On recall.
only 2 dates, my lord, subsequent to this honorable court's order, my lord. Only 2 dates were allowed. On 18th.
How many dates you want?
My lord,
How many days I'm asking you?
my
How
lord,
many
at
days?
least, my lord, 3 dates. My lord, more than 1.5 years was
Maybe.
allowed in case of PW.
How many questions will put on one day? One question.
No, my lord, not like that, my lord.
What is
My
the
lord,
suit for?
At least some reasonable opportunity be given, my lord.
Not a reasonable opportunity. You have cross-examined on 2 dates. Another 3 dates, sir. You are trying to delay this proceeding.
No, my lord. No, my lord. Not at all, my lord. But my preemption application has been pending since 2017.
Maybe. You do not want that to be disposed of.
I want it to be disposed of, my lord. The trial court, Learned Trial Court has stayed that, and against that order, my lord, I have approached this honorable court, and that is also pending.
Maybe.
But at
You are
least,
trying
my
to
lord,
delay.
some opportunity be given. At least one date, my lord, be given.
One day?
One day, my lord. One day.
How much cost you are willing to pay?
The cost, my lord, the
Cost has to be paid.
my lord, the defendants are defendants hail from very poor background, my lord. Whereas these people are land owners and my lord, land dealers, my lord.
Maybe.
They're land sharks, my
What is
lord.
the next date fixed? How many witnesses you have? How many witnesses you have?
I have at least three witnesses because there are three defendants.
You have filed the list of witnesses before the court.
No, because DW has not been started yet. DW has
Who
not.
said? Who said? It has been said that if
No,
you
that
not
is the observation of the Learned Trial Court rejecting.
telling which 3rd of July was for arguments.
No,
And you have chosen not to adduce evidence, not even to file the list of witnesses.
No, Lord, kindly consider the order dated 9th of April, my lord.
How many witnesses can you file the list of witnesses tomorrow? Can you come with the list of witnesses?
In case of DW.
Yes.
Yes, I can. Your lordship.
Tomorrow I'm keeping. Please come with the list of witnesses
Your lordship,
and how much time we will take to adduce.
to cross PW2.
Cross PW2, you have said one day. Understandable.
Yes.
How many witnesses you have? Please come with the list of witnesses tomorrow.
My lord, day after tomorrow, my lord. Day after.
All right. If you want, I can direct that, let it retain its position in the list. So it will be taken up in the next month.
Deeply obliged, Your Lordship.
Yes.
Please, appearance.
Yes.
People are dying for the petition.
If I appear on behalf of the opposite party.
ওটা ফেরত দিয়ে দিন। Yes, Mr. Ghosh, Mr. Dotto, please take it back. Please bring it tomorrow.
150.
এইগুলো একটা কি বলবো?
তোমার কাছে
Petitioner.
but I am from the petition.
Sir, Mukherjee, why this one sheet of paper inside? In every matters I'm finding. Previous matter also.
This is a cost tracker which is I'm not very adept at this, but they say that this is required to be given in the department for data entry or something like that. They can better explain.
What I've been instructed to give a separate cost title sheet along with the brief, along with the filing.
Yeah.
দিয়ে দিন না না ওটা এখানেই দিয়ে দিন Yes, Mr.
But
Mukherjee.
in a
Who are
suit
you?
I am the defendant in a suit for a declaration wherein my deed was sought to be cancelled by the plaintiff. I took out an application under Order 7, Rule 11 to say that the suit is not maintainable. Why I say that the suit was maintainable, I'll come before your lordship with that. But the long and short story of it, that my client had purchased this property pursuant to a probated will. And during the pendency of that, the probate which was granted, he had purchased the property for money value. Subsequently, the probate got revoked by the Honorable Supreme Court of India. But once the probate got revoked, one of the beneficiary, she came and filed the present suit claiming that
you have not acquired any title.
That no, she asked for the delivery of and cancellation of my deed and a declaration thereof, along with the partition. Now, in that particular suit, I
with
took
partition.
Yes, because she says that this is not an intested property. It is not a.
You are an outsider.
I'm outside.
So, if the will has been revoked and if the suit is decreed, you do not become a co-sharer.
Yes, but I took the defense of the judgment of the Ashalata Ghosh to say that I was a bona fide purchaser during the pendency of the probated will. I have purchased, therefore you cannot seek a revocation of my conveyance deed. That was the long and short of my the case. Now, if your lordship kindly comes to the prayer that was asked for at page
what is the ground under Order 7 Rule 11?
The grounds are that there is no cause of action, and that without
action is there, as you have said, Mr. Mukherjee. Cause of action is there.
That is a
They
subsequent
might,
cause of action. No, the other thing is that that whether a suit simplicity seeking a declaration is maintainable at the instance of a person whom says that there was a will. The will having been admitted and a probate has been sought for non-citation, whether she can maintain this particular suit independently to say that there was no will. That is a basic point I'll be urging before your lordship on a point of law. A probate was granted.
What should be the suit for? What should be the relief paid for in such a case?
In such a case, she has to ask for administration first. Without an administration being asked for, she cannot simply say that a declaration be given for cancellation. Because I am a bona fide purchaser, and if I take your lordship to Ashalata's judgment, which your lordship knows by heart.
But Mr. Mukherjee, this has to be it's a mixed question of law and fact.
But I'll just not take your lordship.
Let this be a preliminary issue, will be decided along with other issues, because this is not such a point which you are taking that it's ex facie. It says that.
Then I tell your lordship will kindly relegate on the preliminary issue on about the maintainability of this suit.
Mr. Mukherjee, only maintainability may be framed. Issue may be framed with that has to be framed. I think that will be framed also, even without the court saying. Now,
is it
here,
framed?
If not framed, I will direct that, because in all suits, Mr. Mukherjee will be filing the past suit.
That is
the suit maintainable. So now preliminary issue means it has to be on evidence. So all the issues, evidence will be laid. Then this will be decided as a first issue. If you succeed or they lose on that issue, other issues may not be, because if the maintainability goes, other issues may not be decided at all. So not in that sense of Order 14 Rule 2 preliminary issue, evidence had to be laid in this type.
But why I say this, not much of the evidence to be laid. If it is found that my purchase is bad, and the probate on the strength of the probate my purchase was done, but that probate has gone as of today. Now the only point that remains the interregnum a person who has bona fide purchased the property from the beneficiary. It's not from an executor, but from the beneficiary, can protect the purchase or not. Now here the question comes, when the plaintiff comes and says that no, I seek a declaration.
The plaint one.
Yes.
Where is the plaint?
Page 51 is the prayer, and it starts from page
51.
38. 39, sorry.
But that's not the plaint, Malad. There is an amended
Yes,
plaint.
I'll show.
Should show the amended plaint.
All right.
What I show or I don't show, it is up to me. Let my learned friend not give me the sermon.
Yes.
Should understand the limit of his submission.
Page 51.
I know what I am submitting.
Yes, page 51 is the
amendment.
This is not the plaint which that was filed initially. তারা না একটু আমাকে মামলাটা করতে দে ভাই, তারা লিখে কর অ্যামেন্ডেড প্রিন্টটা বার করে রেখে দে।
So they have paid for declaration as well as for cancellation of
This
that.
was then, my lord, your lordship will kindly, my lord, turn to this was, my lord, the initial
Then
claim
they
that was
has
filed.
to be declared, then partition.
Yes.
So this is, I think, between the beneficiaries and your vendor.
Then, my lord, I will take your
And your
lordship,
vendor.
and no, my lord, I am
Partition is between.
no, I am also a party there. I am the first defendant.
No, vendor, your vendor.
A second
Because-
defendant.
Yes, because you have purchased. So partition, if other prayers are allowed, then your vendor will become a co-sharer if the other prayers are allowed. So partition cannot be between you. That is what I'm saying. So partition is your vendor and the other co-sharers. So only your submission is that this suit cannot succeed because you have purchased the property. You are a bona fide purchaser for value without notice.
Lordship. Now your lordship will kindly come to, my lord,
But
page
the,
194, my lord, which is, my lord, the amended prayer.
One thing, Mr. Mukherjee, when you
My lord.
purchased,
My lord.
when you purchased, the revocation was pending.
No, my lord, I will just, my lord. The revocation was, my lord, by the Supreme Court.
No. Application for revocation.
No, that was not. No.
No, revocation how? From the probate proceedings in appeal, the probate decree was set aside. What happened?
Lord, probate was granted in 1982.
Yes.
Lord, your lordship will kindly take the list of dates not appended to, my lord, the petition.
It's a comprehensive list of dates, Mr. Mukherjee.
Comprehensive, what's it?
No, I have the copy.
All right.
It was
the
1982.
main dates are there.
Yes.
Yes, probate 82.
Lordship. Now your lordship will kindly come to, my
And
lord.
you purchased in 2010.
2010. 2010 I purchased.
Yes.
Now, my lord, your lordship will kindly 2011, my lord, the present suit was filed.
Yes, filed an
Then,
application
my
for
lord, then, my lord,
revocation.
yes, then in 2014, my lord, I filed the Order 7 Rule 11. Then, my lord, there was an
So
application.
basically, your purchase is pre-revocation application.
Yes. And, my lord, in 2015, my lord, the GA was, my lord, filed, which was rejected. Thereafter, my lord, it was affirmed by the division bench, went to the
Mr.
Supreme
Mukherjee,
Court.
it
The
has to
Supreme
be-
Court has
It has to be decided. The suit has to be decided.
But I am only, my lord,
Plain
on the
rejection, Mr. Mukherjee, on
the
this.
question of, my lord, the maintainability of the suit, my lord, that is, my lord, a
Here
grave
it's a
question
big
here.
question of law and fact, whether you had knowledge, what this for
I never
for
had
bona
that
fide purchaser for value without notice, Mr. Mukherjee, some amount of evidence may be necessary.
Lord, I tell you, lordship, only one point why I say this. Lord, as your lordship has seen from the list of dates, Lord, the suit was filed in 2013. And, Lord, I took out the application in 2014, Lord, under Order 7 Rule 11. Now, Lord, your lordship will kindly
From
see in
2014,
Yes.
you could have, Mr. Mukherjee, the suit could have been
Lord,
disposed of by now.
because of the fact that the matter was pending before the Supreme Court and the court was waiting for, Lord, the outcome of the Supreme Court. And Supreme Court deliberated, Lord, on this in 2019.
2019.
2019.
Even then,
And the
we are in
2019 was, my lord, when, my lord, in fact, my lord, it got revoked. So, my lord, this is the dates, my lord, which flows that, my lord, the revocation took place, my lord, in the Supreme Court judgment in 2019.
You have not filed your written statement, Mr. Mukherjee.
Lord, I think we have.
You have filed.
I think they're taking it.
So I think if you have filed, I am expediting this suit.
Like just two things, my lord, may I just indicate? Two things.
Please, whether the issues have been framed, yes or no?
Issues have been framed. Issues.
No. My lord, nothing has been done. I'm telling you.
Written statement filed or not filed?
No. Written statement has been filed.
Written statement has been filed on instruction, I say.
No, if you have not filed, I can
No,
give you some time to file a written statement.
We have filed.
You have filed. Very well. Now, my lord, by the impugned order, my lord, the
Please-
framing of
please
issues
take-
is directed.
Yes.
And, my lord, by the impugned order, my lord, the observations are very damaging. Therefore, my lord, these
Without being
observations.
yes.
Lord, why I say
what
this?
observation is damaging? Please take me
Lord,
to this.
the point that I took, Lord, these have been taken down, Lord, in the order. Lord, kindly see, Lord, the effect of the probate and the revocation and every point was, Lord, taken. And the first was, Lord, the bar of suit under the Succession Act. It was, Lord, 211 and 213 of the Succession Act was, Lord, taken. to say that the suit was not maintainable at the instance of a party who admits that there was a will.
Please take me to your order 7 rule 11 once.
Yes, Lord.
Page
59. Lord, it starts at 61.
Basically, paragraph 7 is your main ground.
Yes, Lord, I take it, Lord, about the maintainability of the suit is, Lord, the moot question here. Lord, we have taken ancillary points,
Yes,
Lord,
yes.
as your
So,
Lordship knows, Lord.
paragraph 7 in the order 7 rule 11 is your main challenge to the maintainability.
Yes, and Lord, about
because
Lord,
according to the order revocation operates prospectively.
That's one on facts, but Lord, so far as the framing of the suit is concerned, Lord, she cannot Lord, file the suit claiming a partition when she admits Lord, there was a will. Once she says that the will is to be revoked, Lord, it goes back Lord, for reprobate. And Lord, I can show that she had admitted about Lord, the will.
Mr. Mukherjee.
Then she has to file a letters of administration first. Thereafter, Lord, she has to Lord, work her Lord, the reliefs. And secondly, Lord, the ultimate Lord, my question will be Lord, having regard to Ashalata Ghosh's judgment, Lord, the purchase that my client had made from Lord, the beneficiary of a probated will, Lord, that cannot be touched into. Because it was a bona fide purchase. And Lord, as your Lordship has seen from the list of dates, it is much, much after Lord, my client had purchased. So this is the point, Lord.
Very small, my lord, very short points. My lord, what my learned friend did not tell your lordship, perhaps, my lord, when this application for order 7 rule 11 was filed, the Supreme Court order was still awaited. Now, my lords, all this revocation happened. Now there is a reported judgment in this matter. My learned, I thought my learned friend would say that, my lord, I just wanted to save time.
Reported judgment on what?
In this matter. Well, kindly comes to paragraph 36.
That is, I said that the Supreme Court had revoked. I said that.
So.
He said that the Supreme Court has revoked.
But he did not indicate what the Supreme Court said. My lord, paragraph 36 is the submission of my learned friend before the Supreme Court in this matter. Kindly see para 36.
I think it is appended to our application.
Then kindly see para 38.
He's showing the reported judgment. It is appended. The order is entirely appended to our application.
Kindly see para 38. That this was a submission, categorical submission made on behalf of the purchaser, who is the petitioner herein.
Not important.
was noted that they have
Yes,
claimed
my
bona fide purchaser for value without notice, but the Honorable Supreme Court clarified that we are only concerned with the probate.
My lord, the other thing was
Yes.
kindly notes that right was given to my learned friend to raise this in the PLA. As my learned friend informed your lordship, what is the status of the PLA? PLA has been dismissed by this honorable court. It has been dismissed. This PLA as on date stands dismissed.
That is because of the non-appearance of the propounder.
My lord, I did not intervene, my lord, when my learned friend
No,
was
he should be
completing-
completing
My lord,
his submission.
My lord, I should expect, my lord, my learned friend to reciprocate the same to me. My lord, this is
I
not the
didn't get
practice.
that, Lord, when I
My lord,
submitted.
My lord, he told me I am giving him sermons, but he is interjecting now. My lord, this is not done. One has to be fair.
No, he has also to be
My
fair.
lord, I have to make my submissions. I did not
I'll
finish.
let you make your submission. Yes.
My lord, kindly sees, my lord, after this, my lord, the probate application came up several times. Probate application has been dismissed. As on date, there is nothing. My lord, today there is no will. Your lordship knows what is the value of an unprobated will which was there earlier on. My lord, why should I file for letters of administration in respect of this will?
No, I'm not going into that because those issues can be decided by the trial court.
And my lords, not only that, now my lords, subsequently, this also, my lord, I thought my learned friend would have pointed out. My lord, there is a direction by this honorable High Court, my lord, to finish off the suit within a particular time. And
Yes,
this
yes,
was moved not at my learned friend's instance, but at the instance of other defendants, and I was also present.
No, that's
No, my lord,
neither
that these-
direction to dispose of the suit.
Yes.
Now, when an application under Order 7, Rule 11
That's
is
also
pending, it does not necessarily mean that the
Correct.
Order 7 Rule 11 has to be rejected.
Correct.
That can also be disposed of.
Yes.
Now it has been disposed of one way.
Correct.
So Mr. Mukherjee has come up considering the issues.
So let it be heard out, my lord. I have no problem. Only thing is, my lord, these are the facts. My lord, one thing is, my lord, they were given an opportunity to agitate this before the probate court. They did not do so. Application for probate has been dismissed. Way back in 2022, we are in 25.
The in Order 7, Rule 11 order, the Honorable Supreme Court's judgment has been taken note of.
Yes, yes.
Where is that? Please show me that.
Yes.
That
Impugned.
your lordship will kindly come to Lord the internal page 5.
Page.
No,
My lord, revocation of probate, my lord, your lordship finds it, my lord, just before the.
There's no page number, I think.
No,
Internal
just,
page
my lord,
number.
second last page.
Second last page.
Yes, my lord. Kindly sees, my lord, the last third line. Last 3 lines. Honorable Supreme Court in 2019. Your lordship got it?
The
Yes,
next
yes.
important question that
Upon a meaningful and holistic reading of the plain.
no the Lord the your lordship is
Well,
that
if your
Lord,
lordship sees, my lord,
after the questions are framed, Lord, the
As
next
such, it can be
important and vital point is the Honorable Supreme Court left the issue. Lord, it is internal page. Are এটা কত রে ভাই? 5.
it's taken care of in, my lord, this internal page 4, my lord, which is the second last page, which mentions, my lord, Supreme Court order in 2019 and subsequent dismissal of probate proceedings. That has also been taken care of and noted in the amended plain. That's why, my lord, the amended plain was important for your lordships to see.
The trial court has also recorded in such a situation whether the plaintiff is entitled to claim are valid matters which require adjudication upon evidence.
I say so. I say
But
so.
directing
But
the
Lord,
issues-
yes. But Lord, only by you have order 14 rule 2. That is what I say.
Order 14 rule to Mr. Mukherjee, the other issues, let all the issues be framed, evidence be laid. Now, if this is to be decided as the first issue, Mr. Mukherjee, everywhere, if the first issue mentality goes against the plaintiff, the other issues need not be gone into.
Lord, may I just, Lord, on 2 things, Lord. But my learned friend was vociferous in saying, Lord, that, Lord, the application for probate stood, Lord, dismissed. Therefore, Lord, although I was given an opportunity by the Supreme Court, I did not agitate. But what was unsaid before your lordship was that, Lord, I was not the propounder. Lord, the propounder did not, Lord, put forward or press for his, Lord, the probate application, and it was dismissed for his non-appearance. So, Lord, I had no opportunity, Lord, as a person who had purchased the property, my lord, to agitate my points in a PLA proceeding. Otherwise, also it could not have been done, as your lordship knows. Because, my lord, the ambit of a probate proceeding is very limited and not, my lord, confined to, my lord, how the title has flown to my client. Now, here, my lord, the only question, my lord, that which I am trying to impress upon your lordship was, my lord, in 2013, whether, my lord, the plaintiff had a right to, my lord, sue my client for a declaration of, my lord, my deed was, my lord, non-est. But in that context, my lord, I only say that she could not have done so, my lord, because she had admitted about, my lord, the will that was executed by the predecessor in interest. Now, my lord, in the event a will is admitted, as your lordship knows, my lord, that the propounder is not coming forward to seek a probate, my lord, the only option is a letters of administration by, my lord, the legatees. The legatees did not come forward, my lord, for a letters of administration. Comes, my lord, and says that as if, my lord, this property devolved by way of, my lord, intestate succession and seeks, my lord, a declaration simpliciter. So, my lord, this is a point, my lord, is a point which goes to the root of the jurisdiction and the locus of, my lord, the plaintiff. Now, my lord, on the question of maintainability, my lord, I am very open to my lord's suggestion that it should go back. But, my lord, the question of maintainability, if it is decided against the plaintiff, my lord, the court need not go into the other questions and it will save the time of the court.
Has to be, but let the evidence be laid by the parties. Otherwise, Mr. Mukherjee, it will again delay. Maintainability one way or the other way, if it is decided in their favor, then again evidence, the entire proceedings will get delayed.
But your lordship will
I'm
kindly, my lord,
expediting,
and say, my lord, about the maintainability, my lord, I have an issue and that has to be decided and the
that has
court
to be
should not-
decided.
court
That-
should not
that
go
will
by
be
the
decided
observations made.
first amongst the other issues. If that is decided, the court will decide in accordance with law.
Issues will be there, my lord.
And, my lord, the observations
Issues will be there, evidence will also be
Also
laid.
be there.
But the observations will not be binding in the learned judge. Not, he has already.
My lord, why should the observations?
Observations, Mr. Mukherjee, the only thing is that the previous observations have been clarified by the last penultimate paragraph. It says in such a situation where the plaintiff is entitled to claim and whether the transfer is valid are matters which requires adjudication upon evidence. So
But
clarified.
only one point is maintainability of the suit. My lord, that is the more point of emphasis.
This application that I have said that,
that is.
after leading
Kindly
evidence.
have a look into that, and Lord, if it is required, your Lordship directs the order 14 rule.
That is why I've said after leading evidence.
No, when my learned friend says so,
Oh,
Lord, I
to
concede.
rely on
I
the Lord,
concede,
then
Lord, I
think
concede
other
when
thing.
he says so.
Because it says, my lord, very clearly.
It does. On
Yes,
facts and law.
where, please see, notwithstanding that a case may be disposed of on a preliminary issue, the court shall, subject to the provisions, pronounce judgment on all
All
issues.
issues. Well, that's what I
Then,
said.
Yes,
then there
where
is something.
issues both of law and fact arise.
Yes.
Here, according
Yes,
to you, in the same suit, and the court is of the opinion that the case or any part thereof may be disposed of on an issue of law only.
Yes.
It may try that issue first, if that issue relates to the jurisdiction or a bar.
Correct.
And for that purpose, if it thinks, please postpone the settlement of other issues until after the issue has been determined, and may deal with the suit in accordance with the decision on that issue.
That
That's
was all
what I'm
through
saying,
my
my lord,
prayer.
Because, my lord,
Well,
what he's
yeah,
saying,
let
my
it
lord,
go.
it's not a bar or a jurisdictional issue.
Well, let
My
it
lord,
go,
what
Lord.
my learned friend is saying,
Let it go,
my lord, the
Lord.
lordship says, my lord,
Order
I will go
14
by
to
the letter
Lord.
of the law.
I will concede, Lord, what my learned friend says.
Disposed of.
Yes. 4, I'm appearing for the petitioner. The learned advocate on record is not well. I'm praying not today.
Learned advocate for the petition.
I, my lord, I am for the petitioner. The
Yes.
petitioner is the, my lord, decree holder And my lord, the decree was put into execution along with a copy of the judgment, a degree of the Xerox copy of the degree. Because my lord, the originally I have lost the suit against which we have preferred appeal. The appeal court set aside the degree of the trial court and against which an appeal was preferred before this honorable court. My lord, the original certified copy of the degree has been tagged with the court of appeal. Thereafter, my lord, this was sent down to the court, this court, and later this was sent down to the court below by this court. My lord, we have not obtained copy of the decree, my lord, certified copy. The record could not be traced in spite of our best efforts. We filed application, my lord, the execution case with the trial court degree so far as that is concerned, and we prayed before the filed also the suit registered before the executing court. My lord, the other side filed an application, the judgment debtor. Now, after disposal of their case under section 47, they have filed that the degree cannot be executed in view of the fact that we have not filed the Xerox copy. We prayed before the court that the record be called for from the.
Why are you not obtaining a certified copy and filing?
My lord, I have not been able to obtain such copy. In spite of that, my lord, the record is lying with the court of the lower appellate court, and also we have not been able to trace out the records, and we have not been able to. Therefore, my lord, we have prayed before the court that the record be called for either from the record sections in spite of our strenuous effort.
Where is your application? Order that.
My lord, kindly look into the application at page 28.
Petition is directed to
I
It
beg
is
to
your
appear
lordship,
for
I
the
am for the
opposite
petitioner.
party. Well, there was a caveat.
There was the caveat.
Yes.
My lord, there is no caveat, my lord.
But
When we had
caveat. But order dated, it was a caveat from 23rd June 2026 from the order.
I have challenged the order dated 2nd July 2026.
The
my lord.
copy may be served. no?
Sorry, my lord, I am against assailing order dated 2nd July 2026, my lord. My lord, we had filed a put-up application, my lord, there was an undertaking by the advocate of the Shama Prasad Mukherjee Port Trust that since there is a deficit in amount of what we were required to be paid, we had paid that amount, my lord. If my lord kindly takes page 47, my lord, of my application. 49. My lord, 49, my lord. My lord, I was the appellant before the learned appellate court in Howrah. My lord,
What is the decree we have challenged?
My lord, I have not challenged any decree, my lord. My lord, we had only, my lord, since there was an order of the learned ADJ Howrah, my lord, that there is an amount of rupees 3,80,000, 82,139 which was due. If I pay that amount, my lord, the advocate of the Shama Prasad Mukherjee Port Trust had given an undertaking which has been recorded that there will be no execution proceedings.
Where is that undertaking?
My lord, page 49 itself, my lord, in the order.
49.
My lord. My lord, if may I just place, my lord, from the second paragraph, learned advocate on behalf of the appellant submits that in compliance of the order dated of the estate officer
has been paid by the appellant.
Has been paid, and my lord, I am the appellant there. And my lord, the second paragraph, learned advocate on behalf of Shama Prasad Mukherjee Port Trust, Kolkata undertakes before this court that execution will not be proceeded with with at this stage, but he prays for early hearing of the appeal. My lord, I am also praying early hearing of the appeal. But what has happened, my lord, all of a sudden on 1st of July, my lord, the persons from this Shama Prasad Mukherjee porters came and they have sealed the entire premises. Then, my lord, on the very next day, my lord, we
Files
had,
an application under section 151. What happened to that 151?
my lord, it's still pending. And my lord, it has been deferred to 20th July, my lord. My only prayer before the learned ADJ was that since there is an undertaking given.
Where is your 151 application?
My lord, page 51, my lord.
51.
My lord.
Been taken.
My lord, it has been sealed. And my lord, my goods are lying there.
Yes, Mr. Nag,
I have
what
no
are
knowledge. I have to take instruction and come back.
you see court's order? You have
Yes, yes,
given an
of course, of
undertaking.
My lord, it's not only he, my lord, there are several other
Or
persons.
proceeding, Mr. Nag.
No, no, no.
Last few orders.
No,
which
I
are-
understand. I understand.
Last few matters, the way you are proceeding, Mr. Nag.
Understand, my lord. But I do not have any instruction. I have to come back, my lord. Tomorrow, my lord.
You have lodged a caveat, you said.
No. It's from the appeal, miscellaneous appeal. It's from a suit the caveat has
No,
been
my lord, there was an appeal
No,
which
it's
is pending and the learned advocate
From the
before the
caveat-
learned ADJ was appearing every
It
time.
shows there was also a suit. From the suit, the caveat.
But
is filed, not from
Mr. Nag, it appears, please show him this order. Do you have an extra copy?
My lord, I'm not carrying it right now, but I'll just provide him within 15
Please
minutes.
show him this order. They've also paid that amount. You have given an undertaking, execution will not be.
Must have been some mistake, my lord, on our part.
Mr. Nag, I'm keeping it tomorrow. Please give him a copy in course of this day.
My lord.
If you find that it has wrongly been done,
Yes,
please
of course.
undo that wrong and come tomorrow, report to the court.
Of course.
My lord,
Of
only
course.
one indulgence, I know, my lord, I may be wrong, but my lord, there are some goods which are lying in that premises which are perishable goods. And my lord, a lot of people are suffering over there.
But
I know I'm
when the
looking at
padlock was put in?
on 1st of July, my lord.
So today we are on?
My lord, today is 13th July. My lord.
I'm keeping it on
Tomorrow.
So you could wait for 13 days, you cannot wait for 1 day.
My lord, kindly pass an order, my lord.
For what?
To take instruction and come back to your lordship. That's better.
Undo that.
Yes,
upon course. Notice to them.
Of course. Great.
Yes.
My lord, this application has become infructuous as during pendency of the civil division, the judgment has been delivered. It has been decreed on contest.
The learned advocate appearing for
Grateful, my lord. My lord, this is my application for expeditious disposal of a title suit of the year 2013. It's a
Yes.
suit for declaration and injunction, my lord. There
What is
was
the stage of the suit?
the stage right now. It has been fixed for ex parte hearing, my lord. There were initially two interlocutory applications pending, my lord. One was a
Interlocutory applications are still pending.
no. The injunction has now been made absolute after an ex parte hearing, and one substitution application of the plaintiff number one is pending since 2019, my lord. That is still pending, my lord.
What is the next date fixed?
Next date is on 3rd August 2026, my lord. It is now fixed for ex parte hearing.
3rd of August 2026 is for
Next date, ex parte
Order
hearing.
22 Rule 4.
No, my lord, ex parte hearing. That application perhaps was not noted by the learned court. It is still pending. My lord, this is my application for an expeditious disposal of a letter of administration, which is of the year. Initially, it was filed in 2020, but it was became contentious in the year 2024, my lord. Here, the matter is fixed for hearing. It is fixed for peremptory hearing, my lord. This is the last order which I
Written
have.
statement filed.
Yes, my lord. Written statement filed. This is the last order of 18th May. The next date is fixed on 17th of August for peremptory hearing.
This application under Article 227Yes.
My lord, in item number 10, my lord,
Yes.
I am moved by Mr. Anirban Ray. He is on his legs, my lord. May I seek for a short passover in this matter?
Five minutes.
Lord, very well. Very well.
Yes.
Very
5 minutes possible.
well.
I'm
Okay.
coming after 5 minutes. Sure. Yes.
Lordship, in item number 10, just now my leading counsel, Ms. Chakraborty, mentioned
Yes.
Mr. Oniban is on his legs before another court, Lordship. If the matter could be kept on Thursday, Lordship.
On the prayer. Yes. Yes. Yes, Mr. Bhattacharya.
Leading hospital, Milord, is before your lordship. Milord, see.
I could not follow.
Milord, a leading hospital, Milord, is before your lordship, Milord. It is, Milord, alleging the wrongful assumption of jurisdiction by the consumer forum over a complaint lodged by a person, Milord, whose child was never admitted, never been to the hospital according to the hospital records. Milord, we are questioning the order of 15th of January 2026. Milord, that is the first annexure, Milord.
15th of January.
Yes.
Yes.
Milord, please come to the first annexure. Milord, page 18.
15th of January admission hearing.
Yes. That order has been questioned by us. Child was rushed to hospital. No emergency protocol was followed there. Milord, according to our records, Milord, admittedly the child was never admitted. And Milord, the child was under a particular doctor who was...
Mr. Bhattacharya may not be admitted. It does not say that it was admitted. It says he was rushed to hospital. No emergency protocol was
followed. With respect, Milord, this rushing to the hospital and Milord, the consequent Milord following of protocol and everything, Milord, is not within our records. First submission to your lordship is the...
These are the disputed questions of fact, Mr. Bhattacharya.
Appear. I will. We have filed our written objection also.
Yes.
Now, Milord, first submission to your lordship is, Milord, the complaint, the original complaint. Milord, a copy of the complaint. Milord, I am sorry, Milord, I don't have. This is the copy of the complaint.
Yes.
Now, kindly see complaint number 3. Milord, it has been, Milord, the complaint is against, Milord. First is Dr. Tridip Banerjee, then is Dr. Ruma Rai, and third is, Milord, Neotia. Now, Dr. Banerjee, on his own accord, Milord, he moved a civil divisional application before your lordship's court. That order, your lordship will be pleased to find at page 27.
27 of
29, I'm sorry.
Of this complaint.
Of the writ petition. Of the civil division, sorry.
The civil division, 29.
Yes. Milord, CO 702 of 2026. Now, Milord, admittedly, Dr. Banerjee was also not, Milord, treating the patient or the, Milord, child who unfortunately...
Stay order has been passed.
Yes. Insofar as Dr. Banerjee is concerned. Now, that stay is apparently continuing. Insofar as Dr. Banerjee. Now, Milord, the second...
Cannot proceed for the others as well.
So the
consumer complaint has been stayed, Mr.
They are proceeding. And they are, despite bringing it to the notice of the consumer forum about this order made by your lordship's court in CO 702 of 2026, dated 27 February 2026. A subsequent order has been made by the consumer forum, Milord, recording this fact and, Milord, directing, Milord, filing of statements. Milord, I was only beseeching your lordship, Milord, our case in the written statement, if your lordship kindly sees the written objection or whatever, Milord. Now, there were 3 other proceedings at the instance of...
What order you are challenging?
My order, admission order, 15 January. 15 January.
If you file your written version, I direct the district commission to decide on the maintainability of this.
My lord, only difficulty is, my lord, since, my lord, one coordinate bench has stayed the proceedings and asked the consumer forum to lay its hands, my lord, till such time the matter is decided. I will be, my lord, humbly, my lord, I shall serve the other side. I shall be humbly beseeching for a similar order, my lord. Till such time, my lord, the consumer forum need not proceed.
Consumer,
and my
how
lord,
do
the
you
first
say
thing is
that
I am first submission to your lordship.
Bhattacharyji, whether
It
the
doesn't
patient-
rope in, my lord, within the
patient
purview.
went or not?
My lord,
did not-
that is our written case.
Yes, so that will be decided.
Yes.
So on that basis of admission order admitting the complaint cannot be set aside on the basis of your written
The
version.
thing is, the same submission was addressed before the WPCRC. Kindly come.
Page 25.
First is, there were 3 other fora, where the person approached. First fora is, WBMC.
Yes, what happened there?
WBMC, declined to give relief to the person, who brought it to its notice. Then is, the WBCRC order, that is at page 26.
26
of this paper.
Civil Division.
Okay, no, of the Civil Division. And 22 is the WBMC order. First is I invite your lordship to WBMC order. Though it is alleged in the WBMC order, which is incorrect. The synopsis of the complaint is that patient developed high fever, etc., etc. It is alleged somewhere in the middle, a little down of the first paragraph. He was admitted to the said hospital at around 6:20 p.m. on 1/1/2024 under Dr. Banerjee, which is a complete erroneous factual recording.
So proceeding is also pending before the medical council.
No, it has been, kindly see the last part, page 50, this is page 23.
Yes.
At page 24.
Yes, the council at its meeting held on such and such.
It's all relevant as a complainant, the expert, etc., and decided to close the case. To close the case.
No, where do you find close the case?
Page 24.
Yes.
24.
The deposition of all the parties and decided to close the case with
intimation to all concerned by exonerating both the medical practitioners, that is Dr. Banerjee and Dr. Roy, involved in the management of the case. Then, they moved the West Bengal Clinical Establishment Regulatory Commission.
Yes.
That order is at page 20. The next page, 25. The complaint would relate to unfortunate death of a young child or boy. We have carefully gone through the complaint that would principally pertain to medical negligence involving 2 pediatricians against whom the complaint has already been approached the appropriate authority. Mrs. Dotto, the unit head of the clinical establishment, is present online. She would submit after going through the complaint. They verified their records and found that the patient never visited the CE at the crucial time. She would, however, admit that the child was born at their center. However, there was no further visit to the CE as per the record of the CE. The complainant
because otherwise it will be conflicting. I think this to be released, better to be assigned along with that.
Well, let the order be passed. We shall take steps. Because that is a different matter. This is a different matter.
Arising out of the same proceedings.
Kind. Kindly do not. Again, I'll
It assigned.
It will be difficult.
Why?
Because kindly be.
I'm observing that. Otherwise,
First of all, that is not a regular bench. That is not a regular. That does not take up, ordinarily civil divisions. It is with Justice Sharma, if I am not mistaken.
Sharma the civil division.
Up to 2024.
Justice Sharma division.
And Justice Gottopal is in any event,
difficult.
No, kindly let it remain, as it is. It is a request. There is no. His lordship had a problem.
Doesn't pick up matter.
This matter along with. Next. List of
Item number 12, I am for the petitioner.
I am for the opposite party.
My lord, your lordship kindly come to the impugned order, my lord. Dated, my lord, 23rd of March 2026.
Yes.
Lordship kindly come to the last paragraph, my lord, of the order. My lord, I am challenging only that portion of the order. My lord, under such circumstances, according to the principle laid down by the Honorable Court in the decision of such and such, my lord, the appellant is directed to pay 10,000 per month on or from February, my lord. My lord, this, my lord, occupational charge has been determined, my lord, without going to the present situation, my lord, because the rent was 360 only. My lord, I have annexed the photographs of the room, my lord. Kindly come to page 77.
Where is the property?
My lord, that Boranagar.
Don't stay in that property. It may collapse at any point of time. Please vacate.
My lord, thereafter, my lord, kindly come to my lord.
What is the market rate of occupation charges in that locality?
My lord, I have annexed the rent agreement.
I'm asking you, what is the rent? What is the market rate in the locality of similar property? Better condition?
My lord, I have annexed the one.
Please tell me, I'm asking you, what is the
one rent agreement I have annexed in the adjacent plot, my lord, which, my lord, 3,400.
So I think please vacate, go there. You will save 7,000.
My lord, what happened, my lord? Kindly come to.
Please don't stay in this property.
Kindly come to page 86.
Please don't stay in this property.
All right, my lord. Kindly.
At any point of time.
All right, my lord. Kindly come to page 86. Page 86. This is my position. I am contesting the appeal, my lord, through my lord, legal aid, my lord.
That's neither here nor there. Please don't stay, because after looking at the photograph, you are risking your life. Please don't stay there. And if you will save 7,000, 3,000, 3,500, you will be getting an accommodation.
My lord, where from, my lord, I will get, my lord? Kindly see page 86. My lord, I am contesting through legal aid, my lord.
No, you said market rate is 3,500.
No, I have annexed. I have annexed to show.
At least you have to pay 3,500. Mr. Banerjee.
My lord, in this building, my lord, this is, my lord, dilapidated condition, my lord.
500.
Yes, he will get some better property as per his averment. His ground is there, it's so bad, any day it may collapse. That is his averment.
This property, Mr. Banerjee, cannot fetch 10,000.
But I have given, my lord, at page 74, my lord, 773 bottom, all the facilities of the property I have given.
Please repair this, then you will be getting 10,000.
Kindly come to
please repair this, make it habitable.
But he is saying that 3,400 is not a similar property.
Adjacent, my lord, I have said
15 feet, no, it's on an alley.
This cannot fetch 10,000. I can appoint a special officer who can say what will be the.
No, the photograph, what she has given me, it's completely black pages. I don't know.
Yes, Mr. Banerjee, please. This is a better copy, I think.
He's showing me. Can I take your lordship? He's giving me.
Repair it. You'll be getting 10,000. This property, Mr. Banerjee, it
On
cannot
a 15-feet road, my lord. One
Maybe
room,
15
bath, privy on the ground floor, one room on the first floor.
But the
and all
condition,
the
you
facilities.
repair it, within 15 days, make this repairing work, you will be getting this. Spend something for repairing. After all, in this condition, you cannot.
The portion, the photograph that he has given, my lord, kindly, my lord, may I pray this, my lord, kindly, my lord, fixes something, what lordship, my lord, thinks fit, and direct the appeal to be disposed of. It is
What
fixed
is
in
the stage of the appeal?
Fixed for hearing. LCR has been called. Fixed for hearing in the month of July. Let the appeal be heard, my lord.
Where is the, how many rooms?
My lord, one room and kitchen in the ground floor and one, my lord, small room in the first floor. Page 74, kindly see not the facilities of the property we have in the written objection we have stated, which has been considered by the court. Page 74 starts from 73, my lord. 73 paragraph A.
This application.
And for payment of the arrears, my lord. The arrears should be cleared off within certain time, my lord. Because
That I think in that order it has been done.
no. Now your lordship is modifying, my lord. So kindly, but it is not mentioned, my lord. It says upon payment,
my
there
lord,
shall be
kindly,
stay.
my lord.
The area should.
$14 my lord, I am for the petition.
Yes.
13 lekha? 13.
My lord, Advocate Anisur Rahman is appearing for the petitioner. Due to some injury, he is unable to come in the court. Praying for not this week, my lord.
This is an appellable order, madam. The order.
Before his lordship is the plaintiff in a partition suit, my lord. A petitioner came before your lordship for rejection of a application under my lord order 6 rule 17 amendment.
Yes.
Here, my lord, the impugned order, my lord, 18/4/2026. My lord, the petitioner seeking for the amendment of the my lord relief prayer, which is already in the record, my lord, all in the pleadings. And my lord, next, my lord, two amendments was seeking in the application, my lord. One is, my lord, the relief, which is already pleaded in the plaint, and the next one, my lord, during the pendency of this, my lord, partition should the defendant transferred.
Where is the application for amendment?
Page 27, my lord.
Page 27.
27.
At what stage you have applied for amendment?
The play, well, it is fixed for, my lord. Now it is fixed for argument, my lord.
Argument?
Both the parties are argued, record fixed for peruse of the record, various amendments. Well, it is prayer, my lord. This is prayer, only for the prayer, because it is already in the pleading to avoid the, my lord, multiplicity of the proceeding.
No, no, not only prayer. Stop.
Mr. Kaur, Millard is leading me with leave of Millard, Mr. Kaur. Millard, I am told, Millard, we are rather told there is Millard an almost identical matter which is running in my lord's list. Millard, this is item number 1581 of Millard, the combined.
Identical matter. Same
All-
order has been challenged.
Millard, I am told Millard two separate suits, but almost identical. That's what Millard our instruction is. Though Millard we have not gone through Millard this brief, but well, that's what our instruction is. If these two Millard,
You are the petitioner in that matter also.
we are yet to be briefed. Millard,
In the other matter.
in the other matter.
I tell you, Lordship, it concerns the same property. Concerns the same property. The issues are overlapping. And Lord, insofar as the other matter is concerned, I am told that Lord, the issues are same issues, more or less. I
What
mean,
is the impugned order?
Lord, impugned order is vacating an injunction which Lord we obtained in the learned trial court. Appeal court vacated the order. We are
Ad interim or temporary?
ad interim. We are in 227 application before your lordships. And I was praying, Lord, if this matter could be taken up along with this and on the whichever date your lordship, Lord, desires.
Where is the other matter?
1581 of the
আমাদের ব্রিফটা দে
আমিও ব্রিফ পাইনি স্যারও ব্রিফ পাননি
আমাদেরও ব্রিফ
But who is for the petitioner in that matter?
তোরা আছিস তুই আছিস
Someone has to be the advocate of record.
Advocate on record is the same. That's not same.
আরে অপোজিট পার্টি সেম অপোজিট পার্টি
Advocate on record is also different.
No, opposite party is the same.
Petitioner, advocate on record is also different.
আমাদের দে দুটো পাব দে
Now, Kintu, do you have instruction to have this matter heard along with this? If they have instructions.
Yes, Mr. Chatterjee, what do you say?
I'm the
But
opposite.
if the suits are same suit or different suits?
Different.
Suits are different but relating to the same property. Same property.
It might be emanating from the same property, but suits are filed differently. Orders, probably stages are also different. If
There
I'm
are
not
two
mistaken.
different flat owners who have filed the suit. There are two different flat owners, but Lord, I believe the cause of action is the same.
It's against the society.
Against Lord,
Against the developer.
against
the developer.
Adjacent plot. Developer owner, whatever it is.
He's saying it is an adjacent plot. We are saying it is part of the
So
same.
that's
plot.
probably been decided. So I don't have to
Anyway,
open my mouth on that. I'll show your lordship that.
No, only that if it is against an ad interim order, why what's the stage of the temporary injunction
That
application?
pillar is a misappeal was disposed of in Mr. Banerjee's matter, if I'm not mistaken. If I'm not
But
mistaken.
No, misappeal disposed of against ad interim,
Against that entry.
and here misappeal is pending.
No, disposed of.
Here also disposed of. No, but
May
if it
I
is
just-
against ad interim, Mr. Kaur, why don't you contest the temporary injunction application?
Lord, ultimately, Lord, I am also aware of the fact that is inevitable. But Lord, let us see, Lord, if we can persuade your lordships to pass the interim order that we got before the learned trial judge. Give me
When the learned trial judge pass the interim order, it will unnecessarily delay Mr.
the only
Kaur.
thing is, Lord, I am trying to protect my right under the suit. If some protection is granted, Lord, in some form, I'll just try to persuade your lordships on that. Lord, kindly, Lord, take it up, Lord. কবে রাখতে চাস বল?
I have no problem. Next week I am in difficulty.
তাহলে
It is
next week এই
eight-
ভালো। Kindly keep it.
This week will not any day. I have no problem.
তুমি পাও আমি পাই একটু ব্রিফটা দেখিয়ে দাও
নেক্সট উইক কবে অসুবিধে আছে? মঙ্গল, বুধবার, বৃহস্পতিবার? উইকটাই নেই।
আর তারপর থেকে না আমার খুব অসুবিধা হবে। I wouldn't even know when I'm here and when I'm not. It's easier if it can be done this week. তাহলে
Friday.
August,
Right.
any day in the month of
August
August.
would be 15th August would be convenient for me.
15th August.
Before
I think convenient for all. So no difficulty on my part.
1st August, I'm not sure.
Third is Monday.
1st of August, I think, is the best day.
No, তুই sorry. তুই any day convenient.
This week.
1st of August, Mr. Chatterjee.
No.
Why?
There will be a resolution, I'm sure.
No, if all the parties come, a resolution doesn't matter.
First of all, I don't think I'll be here, my lord.
First of August, he will not be here.
This week, any day, my lord, pleases your lordship.
Might be a problem.
Then 27th?
Because monthlies, because
Very well.
motions.
27th
might-
July,
might-
27th, 27th, Lord, subject to my lord's convenience. Today is 13th, Lord, we can come back on 27th, if it is.
Keep it after that. But your lordship is not there, right? মনে হয়েছে। এইবার মনে পড়েছে। Your lordship is not there.
No, Lord,
From-
kindly.
That is why I was telling you
Whenever your lordship comes back.
Whenever my lord comes back.
August
13th, 14th.
13th is fine. 13th.
It finishes. There is no.
Yes, I think that's better. If the temporary injunction is.
Kindly do not write anything. We'll come back on the 13th. We try to persuade your lordship. Otherwise, Lord, the process will be expedited. Process will be expedited.
He's gone to the circuit.
Yes.
Yes, my lord. Expeditious disposal of the application which was filed.
What is the application?
Application for substitution in execution case. Title execution 17 of 22. The application was filed on 7/8/25 for substitution of the decree holder's name.
This application under Article 2.
Yes, it is also expeditious disposal.
Of?
It is of the miss case for restoration of the original ejectment suit. I am for the
So this is a miss case under Order 9, Rule 9.
Order 9, Rule 9.
This application under Article 2.
Last stage is going on.
Two applications for expeditious hearing upon the same court by the same advocate.
Get one minute.
And 18 I pay for not this email. आपकी मतलब duty witness he has not come.
What happened on 3rd of February 2026? The learned advocate appearing for application under Article application under
Yes. 20 my lord, complaint case my lord, pending since 2020 my lord, before the district commission my lord. My lord, it's at the stage of my lord, BNA has been my lord filed. For argument it's pending.
argument, it's pending.
Argument my lord.
Final argument.
Final argument.
When it has been fixed.
My lord, 28th of, my lord, I have the order, my lord, till 28th of May it was fixed. My lord, after that, my lord, the orders.
28th of
May, last it was fixed, my lord, for argument.
This application under Article 2.
Great. 21, my lord, I am the plaintiff petitioner before your lordship in a suit for declaration injunction, my lord.
What is the order under challenge?
My lord, order 7, rule 11, my lord, is pending. This is an expeditial disposal, my lord. If your
What is the
lordship
next date fixed?
my lord, next date is 27th of July 2026.
27th of July.
27th of July, my lord.
This application under the next matter.
For expeditious hearing of the suit, my lord. A suit for eviction of a licensee. The petitioners are both septuagenarian persons. They are
What is
living,
the stage of the suit?
neither WO nor WS has been filed till date. It's a 23 suit, my lord. Dates are fixed only twice in a year. Gap of 6 to 7 months.
Focus accepted.
Not yet, my lord. It's pending.
Focus upon the defendant.
Yes.
This application under Article 2.
It is not rendered time bound, my lord. And
Yes.
Lord, I beg to appear on behalf of the plaintiff.
My lord, I am opposing the application.
My lord, the plaintiff petitioner in a suit for ejectment is the petitioner before your lordship. An application filed by the defendant praying for removal of CCTV camera from the common area has been allowed by the learned court below. Lordship kindly takes up the impugned order once.
What is the suit for?
Suit is my suit for ejectment and recovery of khas possession against the
Ejectment of a tenant.
of a tenant.
Yes, my lord. My lord, kindly seize the operative portion of the order, my lord. Impugned.
May I place the order?
Please give me a minute. Yes.
My lord, the CCTV camera. Lordship will kindly bear with me for one moment. The CCTV camera, Lordship, it is installed upon the common area of
Here
the
enter into the facts. The learned trial judge has recorded that it's focused to the entrance of the suit flat. So,
There's
my
a
lord will-
categoric finding
227
by
is
the
not for that.
My lord
Advocate
will-
Commissioner regards the positioning of the camera, my lord. It focuses more on the
My
ingress
lord
and egress
kindly
of the
takes
flat.
up page 29A once.
What is the purpose of installation of the
Because the
To
flat
keep a track of my activities.
flat, Lordship, the flat which is the subject matter of the suit, Lordship, that is kept under lock and key. So it is my premises. He is a tenant in respect of that flat.
that he will focus that?
Exactly,
No,
ma'am.
Lordship kindly takes
And
up
also,
the
my lord,
photograph
kindly
once.
appreciates
Lordship will kindly take up the photograph once, page 29A and
the connection
29B.
was also disconnected, my lord. Which is the reason
Kindly
why
takes up
the
page
151
29B and
application was preferred primarily.
29B, Lordship, it is focusing on the common area. It is not on just because his door is there, Lordship, it does not enter the flat. The CCTV camera does not focus into his the flat. It is only there on the common area, Lordship kindly sees. And the judgment on the basis of which the learned judge in the court will.
Part, it's difficult because there's a factual finding recorded by the learned trial judge, taking into consideration the
report of the Advocate
yes,
Commissioner. my
report
lord.
of the Advocate Commissioner also.
Then Lordship
That
will
was
kindly-
appointed at their instance.
Where is the report of the Advocate Commissioner? Please show me
They
that.
have not annexed it to the application.
Where is that?
My lord, we have not been given a copy of the report, my lord.
এটা সার্টিফাইড কপি তুলতে হবে
Given একটা আমাকে
পরে দিবি দাদা ঠিক আছে পরে দিবি তখন পাওয়া যাবে আরে পরে অ্যাপ্লাই করে Lordship, I am the landlord, Lordship. I just keep this camera there to focus on the common area. It is not.
Alongside my activities, my lord. The
He
ingress
does
and
not
egress
reside
happening
at the
at my
premises. That
flat.
is my very case in the plaint also.
Be that as it may, my lord, it is categoric that it focuses on the ingress and egress more than any other aspect of the premises.
You want, you can install in some other place without affecting the privacy. This cannot.
Lordship may then kindly modify this order to that extent. Lordship, I
apply,
can,
apply there.
I will change the direction then.
For that, you can apply. If you want, I can give you liberty, you withdraw, file an application there. This cannot be done.
Malad, that should also be heard upon merits, Malad, by the court below.
Has to be heard upon the merits.
Absolutely, Malad, because there cannot be a blanket direction of.
Kindly gives me liberty to apply before.
After some argument, the learned Yes, next. 24, yes.
24, my lord, I am for the petition.
Yes.
The defendant is the petitioner before your lordships in a suit for declaration and for recovery
What
of
is the impugned order?
the impugned order, my lord, accepting the report of the commissioners, although it has been found that the report is a faulty one, but provisionally this has been accepted. My lord, the court of
Acceptance of the report of the commissioner is a revisable order.
my lord, so far as this order, the court
So is it a revisable order?
my lord, so far as the concerned, my lord, he has found that the order itself is a faulty.
Commissioner's report, order 26, rule 9.
So order 26, rule 9.
Automatically forms part of the record.
My lord, these forms of the part of the
So you can
record
cross-examine, you can cross-examine, you have cross-examined.
cross-examined. After cross-examination, it has been found that the court, that the report.
So, is it a revisable order? Yes,
My lord,
Mr.
so far
Banerjee,
as
where is that
this has-
Supreme Court judgment? Acceptance of the commissioner's report, no revision lies.
My lord, so far as this court judgment is also there, my lord, so far as this is, my lord, with regard to after acceptance of this report, this will mislead the court at least.
No.
Marked as an exhibit with objection. After cross-examination, court has marked it as exhibit with objection. So all points are open. That is what the court has held.
My lord, the court, the provisional acceptance of the report itself.
Where the court is for any reason dissatisfied with the proceedings, it may direct such further inquiry. So this automatically forms part of the record. Only you have a right to cross-examine. You can point out that.
My lord, that cross-examination was.
So acceptance is automatic.
That is what the court.
Once those deposition report, please see order 26 rule 10(2).
My lord, so far as that is concerned, my lord, the court itself found that this report cannot be accepted, but that as acceptance has been
So,
made, my lord, subject to.
please see the provisions of order 26 rule 10.
So far as the.
See.
Yes, my lord, so far as that is that will be accepted and.
Yes, forms part of the record.
Forms part of the record,
Yes,
which will be
the veracity. So you have a right to cross-examine. You have cross-examined. Now the effect of that, the court will consider that. Both the parties are free to argue on the commissioner's report at the time of final hearing. You can point out at the time of final hearing.
But so far as the court itself accepted that this is a report is called.
Evidentiary value, once a report is submitted, has no option. Yes, Mr. Mitra, that's the finding.
And thereafter.
Correct finding. Correct finding. Mere discrepancies does not make the report null and void. Thus, the provisions makes it once a report is submitted, has no option but to accept. That is what I was telling.
That is the finding.
This application under article, this
that I have
Last part of the impugned order.
provision.
Further evidence. All the
Further evidence also on the commissioner's report. Everything well-reasoned order. Well-reasoned order. Yes, who is appearing? Order 26, Rule 10(3) also touched upon. Rarely it is done. Rarely it is done, but in this order it has been
discretion
done.
of the court, my lord. 10(3) the discretion. If the court comes to the finding that something more is required, that chance has been given.
Yes, so rarely this is done, but in this case it has been done. Yes. Pass over next. 25.
His list, my lord, and your lordship was pleased to allow my mentioning, my lord. My lord, because my lord, the next date is tomorrow, my lord, for the hearing of the Order 7 Rule 11, my lord, application. So, lordship, it should be taken, my lord, tomorrow morning, my, as per your lordship
See,
convening.
let the slips come. Yes, yes.
Extremely great.
Pass over. Pass over. Pass over. Appears for the petition at the time of
For the petitioner, your lordship. If I may please first give a brief overview of the matter, your lordship. A suit in 2003 was filed for eviction of gratuitous licensee. The defendants appeared in the suit, contested to some extent, and thereafter abandoned the suit. The decree was thereafter passed ex parte in 2005. I am for the plaintiff, I put the decree in execution. In the execution proceeding, writ of possession was issued, the bailiff went to take possession and he was obstructed. I filed an Order 21 Rule 97 application for police help. The defendants in 2007, the defendants appeared in such application and contested that. Thereafter, Your Lordship, on 2024, the defendants for the first time came up with an Order 9 Rule 13 application, which first was rejected by the trial court. Then the appeal court directed the trial court to rehear the matter as Section 5 was not heard on witness action. Witness action was done. The applicant defendant has stated that he knew the suit was pending. He was aware about the pendency of the case. He knew about the decree, despite he did not came before the court. And the Order 9 Rule 13 application was allowed without showing any sufficient reason. The order does not show what was the sufficiency of the reason that led the learned trial court in allowing the Order 9 Rule 13 application after almost a decade, Your Lordship, from the passing of the original decree. If Your Lordship kindly comes to the order impugned. The last line of the first page, considering the principle of natural justice as well as factual circumstances, the instant miscase has merit and it has to be allowed. And now, if I may take Your Lordship to the witness action, where in cross-examination it was stated by the applicant that he knew about it. If Your Lordship kindly comes to page 99.
This will further delay your suit.
Despite that, my lord, I have got the decree. That's why I'm praying for stay of my suit and notice upon them why the Order 9 Rule 13 order should not be cancelled. Because I have got the decree way back in 2005, Your Lordship. A valuable right has accrued in favor of me. And that has been overturned just at the drop of hat, Your Lordship, which is subject to correction, is not warranted after the latest Supreme Court judgments and everything, Your Lordship. The sufficiency of cause is also not there, my lord. A new cause has been portrayed, which was not before the Order 21 Rule 97 court.
The learned advocate appearing for the petition.
Fiction.
How can they sell?
They are saying they own the property. In the cross-examination, they have said.
Yes.
If Your Lordship, kindly some protection is given, at least not with regarding the nature and character. With regarding nature and character of the property, if Your Lordship, kindly please.
Yes.
Because the person will be remediless because Lord, both the parties are very.
You obtained an order of injunction in the suit.
Yes, I did.
They can fight.
My lord, kindly come to the decree at page 31, final judgment.
Where is that page?
Page 31 is the final judgment, Your Lordship.
Yes. Yes.
The decree part is Your Lordship. At page 35, I got the permanent injunction in the suit, Your Lordship. The third paragraph of the order portion.
parties are restrained from
Miss Bhattacharya is appearing.
since I'm not inclined to take the dependent
petition.
say so. Yes.
My lord, kindly, I have 3 orders I'll show. Page 84, kindly see.
What is the order impugned?
My lord, order 6, rule 17, initially filed, withdrawn without any liberty. Next, another file, same schedule, allowed in the next date, without there being any granting any opportunity. But kindly see page 84. Kindly see.
Without granting?
Any opportunity to file objection.
At what stage?
My lord, it was for issue had been framed at that. My lord, I'll kindly see, my lord,
trial has not commenced.
My lord, that there is different views, my lord. Kindly see page 84.
What different views?
84, my lord. Kindly.
What is the difference in
My lord,
view?
there are some judgments. Lordships knows it better than me. My lord, kindly see
You
page
show me the
86.
difference of judgment.
Just 1 second, my lord.
Bring the division bench judgment of our court, considering
That
everything.
I knew, my lord. I knew that 87 kindly come. Kindly 87, my lord. Kindly see if my lord feels that I am not prejudiced. Kindly see page 87, my lord. Kindly see.
Page 87, yes.
Is the last order, my lord, 11th August.
11th
Learned, fixed for hearing for petition dated 26, filed on behalf of the plaintiff under order 7.
Not
order
pressed.
6, not pressed. My lord, it happened next order. Defendant file Hajira, plaintiff file Hajira, an advocate's letter dated postal received and an application of so and so, a fresh application order 6 rule 17. None appears on the behalf of plaintiff of call. Let the application be kept with record for further hearing. Next day it was allowed. 4th February, now 4th February it was allowed, my lord.
What can be done? You did not turn up.
My lord, I did not turn up. The plaintiff also did not turn up on the first day. Plaintiff was not there. My lord, kindly consider once he withdraws the petition.
Please show me the earlier application,
my lord,
which
kindly
was not pressed, and the
my lord, page
one
50,
which has been allowed.
my lord, the schedule page 55. Schedule of the previous one.
Please show me the page
55 schedule, and I'll show my lord from his amended plan absolutely same. Page 55. Kindly see 7A, 7B, 7C, 7D. Then 2 prayers. Now his amended plaint is page 61.
This was not pressed.
This was not pressed. My lord, I'll show you why I'm saying so. My lord would kindly come to page 51.
The amended plaint after the amendment was allowed.
Was allowed, yes.
Where is the application for amendment?
But
Please show
that
me
is, my lord, I have asked for that, my lord. It was not, they could not find it. But kindly see, my lord, kindly,
please give me a minute.
Amended plaint page is এটা কি আরে এটা তো দেখাচ্ছি এইটাই তো 7টা হচ্ছে প্যারাগ্রাফটা দেখো অ্যাপ্লিকেশনটা চাইছে যার স্যার এটা পুরনো এই দেখো এটা হচ্ছে পুরনোটা 51টা হচ্ছে দেখো 26 সেপ্টেম্বরটা আর নতুন অ্যাপ্লিকেশনটা বুঝো precious time.
Yes.
2 minutes. My lord, kindly see 7A. My lord is not with me on 7A. Kindly see 7.2.
Yes.
It has also been seen in the my lord, page 55, northeast part of U shape. All shape common area of ground floor was lock and key. Now kindly compare with 61. 7B. It has been seen northeast portion of ground floor was lock and key of the by the defendant, which leading to the eastern side of the defendant. There was western side. Now he has changed, and overhead. A part of the total eastern area was so and so. 7C, the plaintiff have the right to enjoy. My lord, kindly see same. 7C and paragraph 7.
Written statement.
Yes.
File your additional written
My lord, one chance, my lord, I could have. My lord, one chance.
Getting a chance in the additional
My
written
lord,
statement. Please deny those in the additional written statement. This application
in the year 2024, 22nd. But there's
explanation with regard to proviso.
Yes, well, there's nothing, my lord.
With regard to proviso.
Yes, well, lord.
This application Yes.
The defendant is the petitioner before your lordship.
Defendant is the petitioner. Suit for
Eviction,
of a
tenant,
tenant.
7172 rejected.
What remains, Mr. Rai? Please vacate. How soon?
Whether the challenge filed can be considered for the purpose of adjudication of 72 and rejecting my application by holding, those are the admitted rate, you should have to deposit the same. My case is that I have deposited the rate with the rate
I
controller.
cannot verify the challenge, Mr.
I'm not on that. I'm not on that. Till 2016, I have deposited rent. April 2019 with the rent controller. After receiving
till
March 2019.
Till March 2019.
I have deposited before the rent controller.
Yes.
After that, I filed an application.
Summons served when?
That is within time. There is no dispute regarding the same. Mal can turn to page 25.
No, date. This.
Within time. Well, within 1 month.
No. I'm not on that. I want to know. So, this was prior to the issuance of summons, rent controller.
Yes. Prior to issuance of summons.
That is why I want to know.
Yes.
So, then before the court.
From August onwards, Malad, can you turn to page
August 2019.
2018.
Yes.
2018. Malad, can you turn
that
to
is
page
before the rent controller.
Up to deposit current rent before the rent landed court and run from August 2018 and prays for permission of the same. Up to July 2018, I have deposited the before the rent controller. I received
March
the,
29.
No, sorry, Malad, I beg to get it. Yes.
Some other matter you are moving?
No.
This happens when you are burdened with brief.
No. Not burdened with brief, my lord. If your lordship can turn to page 11, my lord will find the date of appearance is 10/9/2018. I have got it. Date fixed on 10/9/2018.
Yes.
Kindly turn to page 25.
25.
At the top, my lord will find the date of filing is on 5th September 2018.
Yes.
Paragraph 4.
So from August 2018, you sought for permission. So up to July, you have paid.
Now, my lord, can turn to my 7.2 application. On the same day, I have filed.
Yes.
Kindly turn to paragraph I. That is at page 30.
Paragraph is highly adjudicate the relationship.
With regard to the statements made in paragraph 3, my lord, got it?
Page
30.
30.
Yes.
What is that? That is their written objection.
No, it is a 7.2 application.
No, paragraph 30 is the written objection.
No, my lord. Written
7.2 is page 27.
7.2.
Page 27.
Page 27, my lord. This is only 27, my lord.
Now I am right, Mr. Rai, you are in some other matter.
No, my lord.
You have taken the correct brief.
Yes, that is with me, my lord.
Yes.
And the mother of the defendants have died on such and such. She was joint tenant. The paragraph number 4 is the disputing the relationship, and this is regarding the payment of the amount. Now, my lord, kindly consider the order impugned.
Yes.
In order to ascertain, my lord, kindly turn to internal page 2.
Yes.
Whether the rent has deposited in the manner laid down by the provision of law, the challans have to be perused. On perusal of the challans, it appears the defendant clubbed the rents 2 or more months and deposited the same in the court by a civil deposit challan. Following the tabular chart reflects the deposits. This is a tabular chart.
So you have clubbed 2-3 months rent along with.
This is 7.2.
These are not valid deposits, Mr. Rai.
Yes, my lord, kindly consider. If that be so, my lord, if your lordship kindly consider.
These are not valid deposits. After entering appearance in the suit, you have to deposit month by month.
Month by month.
So these are not valid deposits.
It can be said the deposit rent made by the clubbing the rents is neither valid nor proper, not accordance with law.
Yes.
So if that be so, my lord, then this cannot be done in 7-1 and 7-2 can be rejected simultaneously.
So according to you, you have to be given an opportunity to deposit that.
Whether 7-1 and 7-2 can be rejected simultaneously. 7-1 and 7-2.
Defense also struck out.
Everything. Even if there is non-compliance 7-1, I have deposited the entire amount. Then if there is, I am entitled to get another at the time of disposal of 7-2. Might not be more than 2 months, but within 2 months at least to regularize these defects. It is not that after disposal of 7-2, during the pendency of 7-2.
One thing, Mr. Rai, it's not a case of arrears.
Admitted.
It's not a case of arrears. It's current. Current, you are obliged to deposit month by month.
7-1.
7-1. 7-1, there's an admitted default because you have clubbed.
7-1, whether
you have clubbed. So you have
post-suit. Post-suit. 7-1, whether post-suit.
So 7-1, so you have not complied with 7-1. So even if post-suit, Mr. Rai, if 7-1 non-compliance, 7-3 is automatic.
Now, 7-2, that is why we consider 7-2. Anything, any amount, subject to
any amount, that's with regard to arrears. And there is a dispute. Here, there is no dispute, Mr. Rai. Hey, persistency at kothay. Here it's a case, Mr. Rai, yes, you are right. If there was some, if it is arrears on, there was some deposit, bad, but here, those deposits you are obliged to deposit month by month. That you have failed by clubbing those. So automatic 7-3 stood attracted.
So what the if non-compliance 7-1?
Mr. Rai, you should not have been granted a further opportunity to deposit.
An amount admitted by him to be due, together with an application for determination of rent payable.
Yes.
No such deposit shall be accepted unless it accompanied
from him. So this refers to on the date when the summons was served, if there was anything due, it's not a case. So here there is no case of 7-2 unless
7-3
dispute the relationship, Mr. Rai. Rightly, 7-3 was right.
Soon possible with the month exceeding 1 year by word specific the amount from the due of the tenant. Thereupon the tenant shall within the month.
Right. Here is the case. There is no dispute. There is no dispute with regard to the period of default. There is no dispute with regard to the rate of rent. So if that is so, so there is 7-2 does not come. Only 7-1, there is non-compliance since you have clubbed.
So clubbing of rent, my lord, if you logically consider the clubbing of rent is it's just month by month. Whether adverse payment of advances can be termed to be valid.
There's a default. There's a default because you have to pay within that. Please see 7-1. What does it say? To pay to the all areas of rent calculated at the rent up to the month previous to that. Such payment shall be made within 1 month of the service of summons. The tenant shall thereafter by the 15th of each succeeding month. So if you have failed to do that, 7-3 automatically stands attracted.
If your lordship, I'll turn to the order, internal page 5 of the
supply the reasons, Mr. Rai.
That is, there is no decision regarding landlord tenant. Well, that dispute is there, that has not been decided. 7-2, I have also raised the dispute regarding the relationship. That has not been decided.
Mr. Rai, what you are disputing?
Yes, this is there.
What? What is the dispute?
Because he is a joint tenant. He cannot be tenanted by inheritance. If she is the
joint tenant.
Mother.
Please take me to your 7-2 once.
Yes. Can you turn to 4?
7-2.
Page 24.
So who was the original tenant? Who was the original tenant? Mother?
Of the mother of the defendants have died on service. She was joint tenant in the rest of the premises.
She was a joint tenant along with whom?
Till her death, and she exercised her own tenancy.
Joint tenant along with whom?
That is said they are a father.
Where have you said that?
No, that is my mother was a joint tenant. My mother exercising her right as an independent.
You are a joint tenant. Your mother was a joint tenant along with whom? You have not specified that.
Dependent upon her husband in the matter of tenancy devolution. Hence, there are serious disputes regarding the matter of devolution of tenancy of the trespasser.
Her tenancy right was independent.
Yes.
Till her death, she has been exercised her own tenancy right. What do you mean by this? It's a vague, Mr. Rai, you have clubbed everything. You have clubbed the rent, you have clubbed all these defenses, everything clubbing.
So at least there is something on record for hearing.
Nothing.
There is no findings over the adjudication.
There is no case made out disputing the
I
relation.
have invited the court. If the court is of the opinion there is no case made out, the court can reject my application.
It's a vague
Now, my
dispute
colleagues,
with regard to the relationship.
so for the 7-1, if you logically consider whether the
Last ditch attempt by you at the revisional stage.
this is, my lord, if you logically consider 7 non-compliance of 7-1 and 7-2 can be rejected simultaneously.
7-2, I will hold that was not necessary.
Then, my lord,
Surplusage. It was a surplusage.
So
In this case, 7-2 did not lie.
if that be so, my lord, then my lord, can you consider how my only 7-3? It should be adjudicated if there is non-compliance of 7-1. If 7-2 is surpluses, then only application 7-3 where the court can scrutinize.
Where is the scope of filing application? Application not needed.
Now, my lord, 7-1, my lord, application is not needed.
7-3 also not needed.
Yes. Then, my lord, where is when the adjudication will be made regarding the?
There is no dispute here. If you have
I bow down to your lordship, my lord, can you consider 7-1, no application required. 7-3, no application required. It is a non-compliance of 7-1. My lord, when does this adjudication to be made? At whose stage?
Court has made an adjudication.
My lord, that is why, my lord, 7-1 can be rejected. There is no requirement of application. Then, my lord, 7-2 is superfluous. It is not.
This adjudication, Mr. Rai, 7-1, there is no necessity to file any application. But at the stage of 7-3, it is to be considered. Maybe application is not necessary, but a decision is necessary. So when the decision is necessary, court is considering whether we have complied with 7-1 and 7-2.
Where is that application? Where is that?
Mr. Rai,
So therefore, there in absence the whether the can so much exercise this power.
can be. Please see 7-3.
No, 7-3, non-compliance 7-1 and 7-2. That is why, my lord, if you logically consider 7.
Mr. Rai, before there is no application needed. So merely suo motu the court can take
So
up.
therefore, the
Or if any of the parties draws the attention of the court, look, there is non-compliance, the court can consider this. Court has done that, considered your challenge, gave you an opportunity, has considered the challenge and held that those are invalid deposits, meaning thereby you have not complied. Mr. Rai, there are two things. If there was a pre-suit default or pre-issuance of summons default, yes, you are saying, yes, there is a dispute for that 7-2 might be necessary. Here, there is no dispute with regard to the rate of rent, with regard to the period of default. So, nothing is in dispute. So, you are obliged to comply with 7-1. So, here you have done, but you have clubbed. Clubbing is not permissible. It shows 7-1 violation is there.
yes. Now, therefore, my lord, when this adjudication, I put this question to myself. What will be the stage for adjudication in absence of any application? Court has no suo motu power for the purpose of adjudication. My lord, can you consider? It is not at the instance of the parties, but at the time of adjudication of 7-1. Can you turn to the order impute? Considering 7-1 and 7-2.
You have taken that risk by filing an application, Mr. Rai.
Therefore, my lord, there is no
Court has
adjudication.
considered that.
So 7-2 cannot be rejected. There is no occasion to consider 7-2. Now, my lord, 7-1 can be rejected on the basis of the post deposit.
7-1, Mr. Rai, 7-1 is says that you have to deposit month.
Yes.
Now, your case is that you have deposited month by month.
Yes.
Now the court is considering whether you have complied with that or not. It's not directing you. It's not directing you. You have filed an application to permit you to deposit month by month.
So there is no question of further adjudication 7-1?
There is no question of further adjudication.
How does your lordship?
Here is the question of whether you have complied with 7-1 or not.
Whether to what extent the court can, suo motu can interfere. Whether the court can take its own to adjudicate in absence of any application to that effect.
What application will be filed?
Non-compliance 7-1. If the plaintiff is so much eager, he can file an application. There is non-compliance of 7-1, rejection of 7-1, or the provision of 7-1. So therefore, 7-1 and 7-2 cannot be considered simultaneously.
7-2, Mr. Rai, there was no occasion for you to.
So 7-1, then 7-1. So there 7-1 was rejected based on the subsequent deposit. But kindly consider 7-1 can be rejected on the basis of considering the subsequent deposit.
Offence can be struck off if the court finds that there is
Non-compliance. Now, my lord, if the 7-1 does not require any no application, 7-3 does not require any application, then my lord, the adjudication by the court at whose instance? 7-2 does not require any adjudication. So any adjudication.
7-2 requires an adjudication.
No, in the present case, there is no requirement of adjudication.
Yes.
Therefore, while 7-2 need not to be considered, then my lord, when the consideration to be made, where this consideration should be made?
Has been made.
That has been made. Well, that is why whether that is my point is that whether the 7-1 can be rejected on the basis of the subsequent default. Even assuming, can I record this? It can be done. My 7-1 can be rejected on the basis of the subsequent default. Then the other 7-1 can be revived. Where my lord says there is no application is required, those 7-1 can be revived.
What 7-1?
It is a
7-1 does not require any
application. So therefore, my lord, whether my 7-1 can be rejected based on the subsequent default after appearance.
Anything more, Mr.
No, this is a submission.
This application under Article 227 33. Pass over. Item number 34.
My lord, for the opposite party on item number 33 and 34.
Please direction given.
I am for
Please,
the opposite party.
Pass over. Next.
5.
Guide.
Sir, you are appearing.
No.
There
My
is
lord, I am for the opposite
no
party.
caveat, Milord, I'm told.
Seeking a copy. But there is a good case and there is
It's a good case.
this is a good case
Good case for whom?
for me.
Oh, my.
And there is no necessity for any interim order because the occupants of the property has already obtained interim order in respect of the property by filing suit.
Milord, my learned friend seems to know, Milord, what is there in the brief. Milord, may I just. My lord, need not,
Whatever
Milord, look
Mr.
at the.
Jana instructed me, I submitted before you.
My lord, need not look at the records, Milord. I just tell your lordship what is the matter about.
You give him a copy.
Wait, you'll come back.
Any day, my lord,
Milord, I believe, Milord, in the meantime, KPT, Milord, don't take, Milord, any.
Order I am saying, my lordship, see,
subtenant মামলা করেছে
subtenant has, they have parted with possession. Now they have filed a suit, taken an interim order and served the copy of.
Get a copy of the.
Now, এই তো মিসাইলের order.
আরো তো
I'll serve it.
আরো আছে।
কালকে আসবো।
কাল না
Any day convenient to you.
কালকে except tomorrow
Except tomorrow, Mr. Jana. has a problem.
except tomorrow any day the instruction is
Day after tomorrow,
That will be difficult.
because he has
That
some
will-
problem. Mr. Jana.
All right. If it is called on tomorrow, please you remind me. Mr. Banerjee, please
তাহলে আমার কপিটা দিয়ে দেয় এখন তাহলে
in course of this day.
Much appreciated.
Milord, one liner would have helped us, Milord.
Yes.
কিছু
বড় লোক আছে। আমি হলে
Item number 2116. You are appearing.
yes my lord
116.
for
For
state,
the
state
date.
expeditious disposal of the execution case
Yes, Mr. Bhattacharya, I think I required your presence because have you taken any instruction?
yes my lord
What is the stage?
my lord
Because for making payment without fail and necessary orders.
I tell you, Lordship, my lord, in 1981-82, this LAKS was instituted, and my lord, the requiring body was public health engineering for the project of water supply scheme under the Govardhana municipality. my lord. Now, my lord, date of possession is 2nd of April 1982. Under section 4(1)A notification issued on 20th of January 1983. The date of award 20th June 1986. Thereafter, my lord, they preferred a reference under section 18. That is of, my lord, 113 of 2006, which was ultimately disposed of on 9th of February 2018. Now, my lord, on 16th of June 2025, the decretal estimate was prepared, and my lord, the requiring body, that is the PHE, they have been requested for placement of the fund on 23rd of December 2025, and the latest, my lord, on 9th of July 2026, the further request was made to the executive.
They have not deposited. Then for that I required your presence.
My lord, this is the record, and my lord, this is the latest
Placement of fund.
my lord, kindly see, my lord, this latest letter, my lord, of 9th of July.
Then the PL account considered allowed fixed such and such for payment.
My lord, kindly consider, my lord, that this last letter of 9th of July.
But Mr. Bhattacharya, what can be done? If you have utilized, you recover from the requiring body, what can be done? The amount has to be paid to them.
Should be.
Then
Should be, my lord.
so your PL account pays for filing a petition for attachment of the PL account. Prayer is allowed. So that application was also allowed. Attachment of PL account.
I find, my lord. Yes, I have gathered, my lord, this.
Then and date was fixed for payment.
That, my lord, that is the reason, my lord, my lord, we have repeatedly asked, my lord, this concerned department for the placement of the fund. I hope, my lord, it will be covered up.
When this was 17th of November 2025. Today we are in July. August is coming. Very soon November will also come.
Yes,
Prior
sir.
to depositing.
The further reminder letter is also there.
That's the Bhattacharya, that is neither here nor there, but your PL account has been attached. And you are sitting tight. That is why I directed in an expeditious disposal matter to serve a copy upon the state.
That is, my lord, whatever is on the record, my lord, I have to submit.
Yes, but now what can be done? If
But
it has
may
been
I
attached,
suggest-
payment has to be made.
Payment has to be made, my lord, because
Make the
we are
payment to
just
recover
stating-
from the requiring body. It's in your hand. Requiring body is also under your control.
Or, my lord, may I suggest one thing, my lord, subject, though, my lord, this is an expeditious disposal matter, my lord, but considering the facts of the case, my lord, kindly give a, my lord, direction upon the executive engineer to give explanation, my lord. That will, my lord, that will solve the purpose, my lord, I tell your lordship.
Under 226, I could have done that. But in 227,
My lord, 227 is
with the no, but the decree holder has been protected. Your PL account has been attached. Mr. Bhattacharya, now you have to take steps.
Or then, my lord, kindly
So I can do one thing. Please take further instructions, do whatever is necessary. I can fix another date. I can fix another date. Plus, please take it seriously. For that, I have directed service upon you personally.
Yes, my lord, I will take care.
None appears for the petitioner at the time of call.
date of order. If the PL account at all attached, but this department will not run its day-to-day activities.
That I do not know that. See, the petition prayer has been allowed.
I know, my lord. I'm going to, after going to
GP
this.
must be knowing which district.
But this is Barashat, not 24 Pargana.
Please take instructions from the GP also. GP of that district.
Not yet appointed.
Not yet. Yes, call the next matter.
My lord, Mr. Tanma Mukherjee is leading me. He has not
hearing matter.
my lord, that from Alipur advocate partition commissioner, my lord, directed to obtain the name of the partition commissioner. I have obtained, but Mr. Mukherjee has not come to the his some difficulties in his shoulder.
Does not come.
Not only not today, my lord. Tomorrow.
On the prayer of the learned advocate for the petitioner.
May it please the Lordship, my lord, I am appearing on behalf of the petitioner, my lord. My lord, disposal, expeditious disposal of application under Order 7, Rule 11, my lord. My lord, filed on the 19/6/2024, my lord.
Surface.
No, my lord. We are the defendant, my lord. We are suffering an application, suit, my lord, which is pending.
Order 7, Rule 11, on what ground?
On surface, my lord.
That is what I
Surface, on surface, my lord.
34.
34.
This application under awesome.
My lord, I am for the petitioner. Order 2119, I am for the petitioner. On the last occasion, since this matter is from Baripur, your lordship had directed me to get the names of the advocates. My lord, Mr. Himadri Biswas is for the plaintiff and Mr. Surjokanto Manna is for the defendant.
This application under Article 2
My application for expeditions disposal 2014 suit and order 39 1 and 2 was of that.
14 or 17?
Subsequently, it was renumbered of 2017 when
Yes.
it came to Chandanagar.
What is pending?
Pending is 39 1 and 2, 39 2A, order 1, rule 10 2, thereafter 39 4 or 39 7. All other applications.
This is my application for expeditious disposal, my lord.
Of what?
My lord, of Order 7, Rule 11, my lord, filed at the belated stage, my lord. Previously, they said that they filed.
Application under Article 227.
Plaintiff decree holder has filed this miss case for final decree in respect of main profit, Your Lordship. This miss case has been filed in the year 2023. The opposite party has entered their appearance and filed their opposition also. The miss case is ready for hearing, Your Lordship. Miss case in respect only of main profit. The plaintiff has recovered their position.
Application under Article 220. Yes, next. None appears for the petitioner at the
petitioner plaintiff.
Yes. Yes.
A suit for preemption under Section 8 of the WBLR Act pending since 2020.
Who are you?
I am the plaintiff petitioner.
This application under Article 220
petitioner in person.
Yes.
স্যার আমি ভার্ডিকের জন্য ভার্ডিক জাজমেন্টের জন্য আমি মানে এর আগে একটা পিটিশন সিও করেছিলাম, সেটা অ্যাকচুয়ালি সেই অনুযায়ী পুট আপ পিটিশনও দিয়েছিলাম, কিন্তু কোনো ভার্ডিক অ্যালাউ করছেন না লোয়ার করতে। মানে রেসপন্ডেন্ট উনি ক্লেমই করতে পারেন না, 246 কে লঙ্ঘন করেছেন, তা সত্ত্বেও উনি লোয়ার কোর্ট কোনো জাজমেন্ট পাস করছেন না।
What is the stage of the suit?
সেই ইস্যু ফ্রেম তো হবে না এখানে অ্যাকচুয়ালি। ইস্যু ফ্রেম উনি
হয়নি,
না হয়নি, অ্যাকচুয়ালি অ্যাডমিট করেছেন, আর উনি তো এমনি ক্লেমই করতে পারেন না। তো উনি 246 কে লঙ্ঘন হয়েছে ক্লেম করার জন্য, 229 সাবসেকশন 1 লঙ্ঘন হয়েছে, 236 লঙ্ঘন হয়েছে, এবং অর্ডার 14 মেনশন করা হয়েছে, অনারেবল লোয়ার কোর্টই মেনশন করেছে রেসপন্ডেন্ট নো টেকেন স্টেপ অ্যান্ড ইস্যু ক্যান নট বি ফ্রেম। অর্ডার 14।
নেক্সট ডেট কবে?
26 আগস্ট।
কিসের জন্য?
উনি ইস্যু ফ্রেম করেছেন জুন 6 জুনে একটা ডেট উনি দিয়ে, তারপর উনি অ্যাকচুয়ালি আমি যখন পুট আপ পিটিশন দিয়েছিলাম, উনি রিটিন অবজেকশন চেয়েছিলেন, কিন্তু রিটিন অবজেকশন রেসপন্ডেন্ট দেননি। তাহলে তো সিপিসি অর্ডার 8 রুলস 5 সাবরুল 1 অনুযায়ী জাজমেন্ট ঘোষণা করা। উনি তো যেহেতু মানে রিটিন অবজেকশন দেননি, কিন্তু করেননি, উনি ফার্দার ইস্যু ফ্রেম করছে, অথচ 7th মে 2025 অর্ডার পাস হয়েছে, ইস্যু ফ্রেম হবে না।
কি আপনি ওই অর্ডারটা চ্যালেঞ্জ করতে চাইছেন?
না, আমি জাজমেন্ট
করেছেন, সেটা কি চ্যালেঞ্জ করতে চাইছেন?
আমি আগে একটা ইয়ে করেছিলাম, সিও করেছিলাম, সেই সিও অনুযায়ী আমি সিওতেও সেটা মেনশন করেছি, সিওর সার্টিফিকেট কপিও আছে, আমি দিচ্ছি।
এখন কি চাইছেন? এক্সপিডিশিয়াস হিয়ারিং চাইছেন না আপনি ওই অর্ডার?
আমি এক্সপিডিয়াস জাজমেন্ট চাইছি।
দিস অ্যাপ্লিকেশন yes. Pass over next. Pass over next. Pass over.
29 Malan, this is my application. Plaintiff in a suit for Plaintiff in a suit for partition is the petitioner before your lordship for expeditious disposal of the final degree proceeding, my lord. Suit was filed in the year 1996.
Final degree proceedings.
Final degree
Partition
proceeding.
suit.
Partition suit, my lord.
Commission work held.
Evidence is going on, my lord.
Commission work held.
Hell, advocate commissioner's report has been filed. Filed in the year preliminary decree was drawn up in the year 2006. 2020 to 11, my lord, advocate commissioner's report was filed. Thereafter, evidence is going on, and till today is 2026. The evidence is that every day speaks for evidence of the advocate commissioner, my lord.
This
17
application under
years.
Article 2.
Lordship, I am for the petitioner. I am praying for. Lordship, I am for the petitioner. I am praying for expeditious disposal of Order 39, Rule 1 and 2 application.
Order 39, Rule 1 and 2.
Yes, sir.
What is the next date fixed?
6th August.
It's ready for hearing.
Yes, Your Lordship.
You are for the
I am for the
this
plaintiff
application
petitioner.
under Article 227 of the Constitution of Yes.
My lord, I am for the petitioner, my lord. Plaintiff's petitioner, my lord.
Yes.
My lord, shoot for, my lord, this request also, my lord, correction. I am praying leave, my lord. In the cost title, my lord, that is declaration injunction, my lord. It is shoot for partition and injunction, my lord.
So it's not ready for hearing.
My lord,
Because
my lord,
service returns,
step.
this application under
My
Article
lord,
27 আগেরটা কোনটা ছিল? C1 ছিল ওটা। Yes. Yes, yes.
Yes, this is an expeditious disposal of a petition under section 13(1) IA of the Hindu Marriage Act, Lordship. The match suit of 2021. Currently,
Who are you?
I am for the petitioner wife, Lordship. That suit was filed on the behest of the petitioner wife. And the suit of 2021, Lordship, the examination of the PW finished in 3 years, after 3 years, and till date, the examination of DW has not started, Lordship. The next date is fixed on 31st of July
For what?
for evidence of DW. The last order is not annexed, Lordship. It's
17th of, it is PW1 a special chance.
Yes, Lordship, the last order I'm just. Yes, Lordship, the order number 39, 17th April 2026. After that, the matter was fixed on 11th of May 2026. On that date, the evidence of PW has been finished, Lordship. But after
PW has been finished.
Yes, Lordship.
Now it's PW2.
No, there's DW. Only one.
Only one witness.
Lordship. After
So-
that, 2 dates have been passed by, but
So
still
the defendant's witness has been fixed now on
31st of July,
31st of July.
Lordship.
This application under Article 226.
Petitioner, my lord.
Yes.
Suit for recovery of possession of licensee. Suit is in the year of 2014. My lord, in spite of earlier one order of early disposal was passed by your lordship in the year of 2021. My lord, still now cross-examination of PW1 has not been completed, my lord. Next date is 2nd of September.
This application under Article 220. this application, you are the plaintiff.
Yes, ma'am.
This application.
Already the
Yes, next,
petitioner has approached the
next.
honorable court, ma'am. Wait for
Yes.
My lord, defendant is petitioner before your lordship. Defendant is a septuagenarian citizen, my lord. The suit is for declaration and permanent injunction, my lord. There is a miss case pending order 39 rule 2A.
Rule 2A.
Rule 2A. And there are lots of applications pending in your in this suit, your lordship. So expeditious disposal of all the application as well as miss case and
This case is not ready. It's at the SRID stage. This case cannot be directed. This application under Article.
Lord, I am the defendant, my lord, in this suit, my lord, was challenged. Herein, my lord, the plaintiff has challenged the election, my lord, and thereafter, my lord, I was the elected. We were the elected members, my lord. We have resigned and filed an application for fresh election. That is pending, my lord. The application is dated 20th of January 2026. It's at page number 107.
Injunction is pending.
My lord, injunction was granted. Thereafter, my lord, we are the elected members. We have resigned and we had filed an application for fresh election. That is remaining pending. That is dated, my lord, 20th of January 2026, the application at page number 117. I only want expeditious disposal of the same. Because in effect,
the order sheet does not record that.
Kindly take some, my lord, at order dated 20th of January.
Order dated 20th of January.
My lord.
For hearing of the petition, which petition it has not been stated?
Defendant number 5 and 5 to 52 file a petition with a prayer on the ground as stated therein. This is the petition. It's at page number 117.
But that application is not fixed for hearing.
Well, this one will
fixed for hearing is the injunction. Or the 9th of July, what was fixed for hearing? 20th of January?
My lord, 9th of July, my lord, this application was fixed for hearing, my lord. New presiding officer has taken charge. My lord, the matter has...
Application under Article 227 of the Constitution of India is
is there, my lord. Kindly, my lord,
Nothing will be done.
my lord, one, my lord, more, my lord, lordship knows the apartment. I do not want to name it. More than 500 members. The my lord, building, my lord, is dilapidated. But at least, my lord, one month, my lord, at least, my lord, one, my lord. Kindly, my lord, one time limit may be provided, my lord.
No.
1 month, 2 months, anything, my lord.
Time limit, sir. Yes, so
Because they will go on, my lord, continuing. Kindly, my lord. Kindly, my lord, any time limit.
as expeditiously as possible.
Kindly, my lord, kindly. I do not.
So what next? On the next matter.
Actually, at least, my lord, one month or 2 months, anything, my lord.
Yes.
I beg to appeal for this.
Yes. What the 1?
3-7.
3-8 na 3-7?
3-7 হবে না 5-1 না 3-7 আমার
5-over 2-1
আমি আছি
3-7 স্যার কি 5-over কোথায় যাচ্ছেন
আমি
2-1
3-7 আমার
yes
হ্যাঁ 1614 1614 Lordship, this is my application, Lordship. Lordship, we being the Port, Sam Prasad Mukherjee Port Trust of India, we had given land to the opposite party. Thereafter that, we had initiated proceeding under the Public Premises Act. They had been evicted. Now, the amount of money which they had not paid during their eviction and mean profit, Lordship, we issued a certificate. Now, that certificate is Annexure B, Lordship will kindly see, which is at page 16 of my Lord's brief.
Yes.
Now, my lord, what happens is, my lord, under section 4, if my lord kindly allows me to place that particular act, that is Bengal Public Demands Recovery Act.
Yes.
Now, lordship, here, my lord, we may, after that, we may make an application and the certificate is issued, lordship. Then the execution proceeding under section 4 lies under the Bengal Lordship, Bengal Public Demands Recovery Act.
Yes.
Under section 4. So, my lord, we filed an application under section 4 before the learned magistrate, Lordship, which the order sheet is collectively marked, Lordship, at page 19. This particular proceeding was before the collector. I stand corrected, Lordship. This was done, Lordship, will kindly see page 19.
Yes, certificate officer.
Yes, Lordship. We have given it on 19/2/2023, Lordship.
Yes.
Now, Lordship will kindly flip over the pages and my Lord will kindly come to the last page where Lordship 8/1/2024 is the date. Last page.
Yes, yes.
Lordship, here they received a communication from SD Bhawanipur PS dated 7/11/2023 regarding the company status.
What have you done, Mr.? All the directors passed away. What have you done?
In my reciprocal submission, Millard, why I am before your lordship.
It transpired that the board of directors are dead. Company is closed. Whom you will now?
Now, Millard,
you will realize.
My understanding is that after that, the learned collector is not fixing any date whatsoever. Now, my lord, this particular proceeding should be brought to a logical conclusion. We are saying, my lord, that there are properties and others are there who can be saddled with the responsibility. But, my lord, this needs to be brought to a logical conclusion because there are other provisions.
If the parties, board of directors are dead, you have to take steps.
My lord, we will take steps.
Against whom it will proceed now?
My lord, will kindly allow me to place my petition, the statements, averments, lordship will kindly come. My lord will kindly appreciate if the person dies. Substitution steps, an order is passed for taking steps. Now, lordship will kindly come to my page 6 of my petition.
Yes.
Lordship kindly takes up paragraph 3, subparagraph C.
Yes.
Lordship has got the learned certificate officer has, without any justifiable cause, failed to list or take up the matter for hearing on or after January 1/2024.
Mr. Trivedi, against whom it will be proceeded? You have to take steps.
My lord will kindly appreciate. I totally bow down to what has fallen, my lord. But my lord will kindly once again flip over the pages and come to the last page, that order which I have shown to my lord.
8th of January.
8th of January 2024.
Yes.
What my understanding, lordship, is of the practice that either any direction has to be given, my lord kindly comes to the proceedings, my lord. The act itself provides, my lord, that they have to give me a direction for taking steps.
Yes.
To come up with, but my lord, if they don't list the matter,
let there be a direction by your lordship to bring the proceeding to a logical conclusion. The matter cannot be kept in the limbo pending without passing any orders. My lord, even no date has been fixed subsequently thereto. My lord, kindly seize the order of after 8/1/2024. No date has been fixed. Either you dismiss it with reasoning or you allow us to take steps. Fix up a date for taking steps. We'll take out appropriate applications.
You will appear for the certificate officer. You appear for the certificate officer
My
also.
lord, now so these are few matters where maybe my lord, I have taken.
So you appear for both of them.
My lord, now so I cannot even appear for my other private matters. The situation is this, my lord. So, lordship, what I'm humbly submitting is.
Do one thing. Please
Lordship.
serve. Let us see whether anyone is there. Please serve upon the certificate debtor as well as the
Collector. Lordship, maybe serve it on the collector, my lord, because certificate. Because if they are saying the police has said that the certificate police has given that all the directors are dead and company is closed. Now, lordship, what we need to understand is that we have to go to the registrar of companies, try to find out, my lord. Now, my lord, after that, we can always come up with better particulars and make an application before the concerned department. But, my lord, if the date is not fixed, if the matter is kept pending without fixing any date, we cannot take out any application. My lord, will kindly appreciate. If supposingly the
I appreciate that, but unless please do that, take that steps whether anyone is there.
So, my lord, that direction should, my lord will kindly.
Petitioner is directed to serve a copy of this.
I'm grateful.
Yes. 140.
My lord, I am appearing on behalf of the petitioner. My lord, the petitioner has issued a filed a material suit number 254.
Who are you?
I am the petitioner. I am husband.
Husband,
Since
yes.
long 2020 matter has been pending before the Ladder district judge Chinsura, and the unnecessary adjournment has taken by the opposite party. My lord, if you
Examination of PW1.
yes, but if your lordship kindly trouble to turn in last order.
Any order for maintenance?
Yes, maintenance has been paid, my lord. In kindly, if your lordship kindly see the order number 30 dated 25th November 2025. In the last paragraph. Order number 30 dated 25th November 2025, my lord. He has paid under section 127. The petitioner has already paid the maintenance.
This application under Article 2.
My application for expeditious disposal, Your Lordship. Your Lordship, this is the one miss case number 83.
What is the miss case for?
86. This is under Order Rule 21, Order 21 and Rule 101. This is pending before the Shialda Court, Your Lordship. The next date is fixed on 1st August for further clarification and awaiting orders. Your Lordship, if I may place the matter before Your Lordship.
So you want expeditious disposal of what? Miss case?
Miss case, Your Lordship.
Title suit is pending.
Title suit is pending. This miss case is from the title suit, Your Lordship. We had preferred one CO in the year of 1998, where the title suit was stayed and it was ordered that the miss case be heard within 3 months expeditiously. But the same has not been done. The order was passed on 29th of August 2002. So all these years or 20 years have passed, but still the miss case is pending before the Shialda Court, stating that some records must be taken from the Alipur court, to be transferred from the Alipur court. If Your Lordship will take page 35, the order starts from there. It's similar orders passed on 13th of January, then on 13th of February.
When the decree was passed?
The decree was passed in the year of 1989, Your Lordship.
Then how this suit is pending?
The suit is pending for so long. There's a suit property, Your Lordship.
Yes, sir. The petitioner is
My lord, this is the case of eviction of 2023. The learned court have given ample opportunity to the defendant to file the written statement. So, my lord, I have come here before the lordship, my lord. On the 15th of July 2025, I have filed a Order 11 rule petition for tracking of the defense.
that is pending.
My lord, actually, during pendency of the case, on 18th of May, it was heard. Order was no passed. So presently, my lord, my humble submission, the prayer portion I have also mentioned. Kindly, about the learned court, expedite the matter.
Suit.
Exactly.
This application under Article 227. Pass over next.
4-6, my lord. I am for the petitioner, my lord. The defendant number 4 is the petitioner in this matter, my lord. Praying for expeditious disposal of the title suit number 117 on 2020 12, my lord. The stage is at the order 39 rule 1 and 2 is about to hear, my lord. On the date was on the last Monday.
What is the next date fixed?
The next date, my lord, I yet to be informed, my lord.
Application under Article 227 of the Constitution.
Second divorce application, because my lord, in the first one what happened is that my husband had told me that we are going to circulate mutually. So one order 20
statement filed.
No, he has filed a non-maintainability petition because this is the second divorce application.
That application has to be hard.
Yes, that application has.
Application under Article 227.
Petitioner Lordship, this is a money suit of 2014. This has been subsequently transferred to Alipur in the commercial division. I have filed one application of section 94 on in the month of December. After that, several orders page Lordship, it is in the order. After the several orders were passed, several adjournments were given on the prayer of the defendant Lordship, but this application is not disposed of. as this is a matter of lump sum amount, so this application was made to just to restrain the defendant to not to sell their property.
What is the application for?
Section 94 B, C, and D, Lordship.
What is the number of that application?
Number of that application?
Yes. What is the IA number?
Lordship. So it is filed in the Alipur Commercial Division, Lordship.
What is IA number 1 of 2025?
Lordship, there is initially there was a money suit number in the Tumluk.
IA number 1 of 2025. Are you not ready? Please go through the brief. Yes, pass over next. Password to dekhe din, password chalo. IA number. Ache.
2128. Lordship, I am for the petition, Lordship. Lordship, I am for the defendant in the suit filed before the one. Lordship, the suit was filed for partition of the suit, Lordship, and that was filed on 2021, Lordship. Thereafter, Lordship, several date has been passed and the adjournment has been given by this learned court, Lordship. And Lordship, I am praying for just expeditious disposal of the title suit number 1524.
Is the statement filed?
Yes, Lordship.
There is also a counter claim.
No, Lordship, the plaintiff has filed one order 6 rule 17 on earlier date, Lordship, in the year of 2023, and that has been rejected by the learned court, Lordship. And till
there is a counter claim also filed in this suit. What are you saying? Order sheet says so. Thik file dilen to. What is the name of the parties?
Lordship, I am for the plaintiff.
What is the cost title?
Anita Das, Lordship.
Anita Das?
Yes, Lordship.
Yes, there is a counter claim. Plaintiff filed a written statement to the counter claim.
Lordship, they have filed the one application in the year of 2022, Lordship.
What is
for
the
filing an all document, Lordship. Production of the all documents.
There is a counter claim also. Have you gone through the brief?
Yes, Lordship.
If
Lordship,
not,
I filed the
go
written
through the brief.
objection, Lordship.
Yes, pass over. Not today. Yes,
In a difficult situation, I am mentioning, my lord, I was not mentioning since morning. My lord, what happened, my lord, on 9th of July, my lord, an order has been passed by the court below. Now, my lord, I was prepared a divisional application on the basis of the communication made. I was supposed to get the certified copy today. Now, my lord, my counterpart called me up saying that the file is kept with the judge's chamber, my lord, and she is not able to get the certified copy. She has taken inspection and, my lord, she has jotted down the order. I have checked up the server. The order is not in the server also. Next date is 16th of July. So, my lord, court says that I will not get the file down and it is kept in the chamber. Now, till 16th of July, I have nothing. Now, my lord, in that scenario, I am challenging an addition of party order who has been made a party, my lord, in a misappeal where
it has been allowed.
It has been allowed. Now, my lord, in suit, that application is still pending, but in misappeal, he is added. And in my suit for declaration and permanent injunction, our adjacent property owner is being added. So, this is very strange. Now, my lord,
Chatterjee, without the order, how can I decide?
That exactly, my lord, the records has to be called for. It is kept in the judge's chamber. But I am in a situation where I have to contest with a party who is not at all a party in the suit, just because an erroneous order comes in, my lord. So this is the order typed version, my lord. I have annexed it, my lord. And kindly see, I have a recalling application. Considering my recalling application, this order is passed.
No, this is the
last order, 9th July, which has been passed by the court. And this is one of the impugned order. And 16th July has been fixed. I applied for the certified copy. I can only, my lord, take inspection and jot down the entire order, my lord, in a paper.
No, this is the letter of authorization.
No, my lord, the first page, just the page, my lord, just turn.
This page, it's
This is authorization who is causing the affidavit. That's why. Kindly see the order which is typed down, my lord.
It's an incomplete.
No, that's a complete order which has been typed down.
Please see, it's not the complete thing. Oh, the next page has come fast.
Yes. In this hurried manner. And my recalling application has been turned down by this order also.
I sought a recalling, my lord, of the earlier order where learned trial court holds in this order that application was heard without the absence of the appellant. He rectifies. He says that yes, it has a mistake on the part of the court.
Mr. Chatterjee, who will take the responsibility of this order?
Now that's why I say we'll call for the records now. Because if the learned honorable judge keeps the file in his chamber, my lord, I become remediless. I cannot approach anywhere. I cannot raise aspersion against the judge also by saying all these things in a petition. Because these are all what are coming from my counterpart. Then the records needs to be called for.
16th of July is kept for what?
For hearing of that misappeal again, in which the addition of party is allowed.
All right. Leave to file কোথায়?
Type copy. Just only
yes,
that.
but someone has to sign this. Who is taking
my own record will take that responsibility.
That is, you have to do that with a copy of the without the certified copy, but with a gist copy of the gist of the order. Typed copy of the gist of the order.
Kindly text it out on Wednesday, 16 July is the date, my lord.
15th. 15th, maybe by this time you can get this also.
Yes, maybe.